Lordship, with your leave, my lord, as an extremely urgent matter, I was compelled. Normally, my lord, it's not proper to mention, but kindly say, my lord, what is happening? There is a matter under the heading hearing, item number 698. I'm mentioning upon notice, my lord, there was an interim order passed initially since 2021 that no coercive steps will be taken against my client. This pertains to the case of my client was that because of the resolution plan, all the demands arising out of the assessment commencement of the CIRP will stand extinguished under the plan following the ratio of the honorable judgment passed by the honorable Supreme Court. And Lordship has also recently followed the same in the matter of Rabirun Vinimay recently. Now they are, irrespective of the interim order, they are continuing to send us the further demand letters. They are continuing to issue us demand letter. This is the last demand which we have got, dated 17 December for assessment year 2017-18. Kindly see the first page. This is also covered under the order of the Honorable Apex Court. Now, my lord, this item is 698. It is in the hearing list. It is the third matter. And Lordship, last order, when we came before your Lordship for extension, a handover, this was on 26th November, Lordship had fixed the date of hearing on December 8th. But because of the urgency, Lordship fixed the date.
Ultratech Nathdwara Cement.
Yes, now it is Ultratech Cement. Now it is Ultratech Cement. Now it is Ultratech Nathdwara has merged with Ultratech Cement. Now we have carried out the amendment.
It is not Ultratech Nathdwara.
Now it is Ultratech Cement. Now it has merged. That portion has been covered. We have already taken care of. We have already amended the rate pursuant to the leave granted by this court. Now issue is very small. Lordship, it is the third matter in the hearing under the item number 690. Hearing starts.
Ultratech, if it is Ultratech, I may have to release.
Why, Lordship?
Unconnected, but still.
Your Lordship had extended. Your Lordship already extended the last.
Because it was Ultratech Nathdwara written there.
Still, all companies.
Maybe.
Lordship has some difficulty, but there were hundreds of thousands of demands come.
Yeah, that not in this matter, but still,
obviously cannot be in this matter. This matter, my Lordship had never the occasion to appear.
Not in this matter at all, and not in any matter connected with income tax.
Then let it appear as to be mentioned. I don't have any objection. I will
not have. Nobody will have, but still. It's proper, because if it was Ultratech, if I had noticed Ultratech in the order, I would not have given on that day.
No, now it has merged with Ultratech. That is a holding company. Ultratech Nathdwara was the subsidiary. This is the erstwhile Binani.
Eta kalke to be mentioned.
Nathdwara is the erstwhile Binani, which we had taken over under the plan.
That is why the problem. Anyway, I'll release it. You'll still have interim order.
Yeah, it is the end of this month.
Item number 6.
Just a minute. Kalki to be mentioned. It will appear as to be mentioned tomorrow.
Item number 690.
Yes, item number 644 of the daily rate.
44.
Yes, very extreme urgent matter, because the respondent authority in one hand accepted the license fee of the petitioner for a period of up to March 2026, and on the other hand put the padlock on the petitioner's shop on yesterday at 2 p.m. Not kindly heard the matter.
What is this matter? What have you challenged?
Challenge the eviction order.
Eviction order you have challenged here. Why? There is a provision for appeal under Section 7.
Under Section 7, that's true, but without following the provisions of the Act, Unauthorized Occupants Act, filed passed the order. Initially, petitioner challenged the same and directed the petitioner to make a representation for extension of renewal of
urgent motion. You give notice.
Lord.
If the other side doesn't come, I will not take up. I'm making it clear.
My lord,
Even if it appears
Lord.
under urgent motion, if both sides are not represented, I will not take.
I shall
Yes.
my lord, I'm mentioning item
Tomorrow-
number
tomorrow
706. Item number 706. Under the heading hearing,
706.
706.
Yes.
Well, this matter was heard by your lordships twice, and your lordship was about to pass the final disposal order. At that time, my lord, the other side took a time that your lordship kindly give last opportunity to file an affidavit. My lord, affidavit was filed immediately. Thereafter, matter disappeared due to change of determination. Now, determination was given to your lordships. Very short matter. If your lordships kindly consider any day subject to your lordships convention.
Very well.
It was
I'll
heard twice.
indicate a day because there are certain hearing matters which have been mentioned. If near a
Milord,
indicate a day.
Milord, mentioning for three analogous urgent matter, Milord. In all the cases, Milord, bank accounts of the petitioners have been attached.
Mention the grounds.
Yes, yes,
Here in
yes,
the
Milord. It is so urgent, Milord. It is so petitioners is unable to file.
It will appear on some day. Not
With the
tomorrow.
leave of your lordship, this is the second occasion I'm mentioning lordship because lordship was pleased to tell me on the last occasion that since the list was heavy, there is great urgency in this matter. What has happened, my lord? I had imported certain syringe which are to be used for veterinary purposes, which does not require compulsory certification, which is applicable for humans. In humans, all syringe has to be sterilized. In veterinary use, it need not be sterilized, and that is how it comes. However, and this I have been doing for the last 10 years. Now, suddenly, they are insisting on MD14 license. MD14 certification is essentially a certification which is given for syringe which is only single use for human use. Now they are insisting the same for veterinary. Globally, that is not the standard, and that has been also agitated. I had also paid the duty. I said, okay, you release, I will fight it out in the case, in the court. And by that time, I had already paid 3 lakhs, which has been taken by them. Even then, they are not releasing my goods. Lordship, they have a shell life. Lordship could kindly take notice of the same, that these syringes have a shell life. And now every day, due to it being stored with the customs authority, I'm not able to use it even after paying the entire duty. Lordship, there is great
What is the
urgency.
item number?
Item number is 543. I have already put the other side on notice. They have received it. I have intimated.
543.
543 of
দেখুন দিদি ওটা দিয়ে দিন দেখুন একদিন
SM
মার্কেটিং
SM Marketing Agency.
দেখুন ওটা আর্জেন্টে একবার দিয়ে দিন। You have mentioned your grounds of urgency?
Yes.
দিয়ে দিন।
Lordship,
Your Lordship, may I-
682, the matter is under application. I beg your Lordship to take the heading application at your convenience.
Sure, I'll take it someday.
Lordship,
Your Lordship,
I'll
may
fix a day when I'll take up application.
Lordship, one is new motion. May I hand over the
Please hand.
Your Lordship, may I be permitted to mention item number 390? Your Lordship, I had challenged a search and seizure operation in the writ petition. However, the writ petition was heard on 11th September 2024 with the direction that the matter may appear in the monthly list of December 2024 under the heading for orders. However, after that, the writ petition has not been taken up due to paucity of time, but thereafter, consequently, a show cause notice was issued, and subsequently an order has been passed, Your Lordship. Your Lordship, if the writ petition is not heard, recovery proceedings may be initiated.
And what had you challenged in the writ petition?
The search and seizure operation was challenged as it being illegal without following the due process as mandated. And
Has culminated into an order in original.
yes,
I
Your
mean,
Lordship.
adjudication order.
Yes, Your Lordship. It is appearing as item number 390 in Your Lordship's copy.
90.
Yes, Your Lordship.
What are these applications for? Two
Your
kinds?
Lordship, CAN 1 and CAN 2 are, I had filed the CAN applications when the show cause notice was issued, and the CAN 2 is filed in December 2025, challenging the order, adjudication order.
Very well, give your slip.
Yes, Your Lordship.
You have mentioned your grounds of urgency.
Yes, Your Lordship.
Lordship, this is for information in the
Please give.
Much
Yes.
obliged, Your Lordship.
If I need permitted to be mentioning a matter, it's running at 5:59 of the daily cause list. I had challenged the show cause notice dated 25th September 2025. The writ was filed on 18th December 2025. 3 chances of opportunity of hearing has expired. First was given on the 18th of December 2025. Second was given on 5th of January 2026. And third was given yesterday, 12th of January. The department is going to pass an order, and I have challenged the show cause notice on jurisdiction and it's arbitrary. And the thing is, the primary challenge is that at the stage of show cause notice, they have prejudged and adjudicated my case, that they have not done a case of preponderance of probability. They have not identified the particular wrong that I have committed. They have just denied my purchases. And
You have participated in the show cause, or you have?
I have participated, I have, for the summons, I have personally appeared in the summons. I have submitted documents. My suppliers have.
Why do you say it is without which is the item number?
Because it's at 5:59. Manju Chanda versus Women of India.
Very well. Give it. Let us see.
Period 621. It's a new filing, Lordships. Here, the writ petition was challenging a show cause notice, which has now culminated into an order also. And on the grounds of 62B, parallel multiple proceedings, already anti-evasion wing had conducted a scrutiny. Now they have issued a show cause notice, the another wing invoking 74. Since last 4 years, they were before me. I had responded to all the notices. Now they have confirmed arbitrarily a demand in 2 crores. And Lordship, new filings actually is coming because it is the new filing, the date is WPA 340 of 2026. I have challenged the jurisdiction, Lordship, 62.
देखिए 621 तो नहीं मतलब to mention correction for order man correction हाँ what is the mistake
line number 4 and 5 what date of representation instead of 7th February it has been typed at 1st February
अच्छा ठीक है date correction दिए थे कल की दिए
to mention a matter upon notice. The issue here is that I had a loan with a bank, a nationalized bank, which I got transferred to another nationalized bank. Here what has happened, they have demanded certain prepayment charges from me. First and foremost, the legality of the prepayment charges itself is in challenge. And the second very crucial factor is I'm a micro unit. In terms of the government notifications, they are not entitled to charge any prepayment charges. Despite that, the bank has charged it from me. I have given it because I needed the loan.
Year? The hearing
it is of 2022 hearing matter. But I have a micro unit, I'll go insolvent. That is the difficulty now. More than 30 lakhs is blocked.
It's appearing in the list.
No, it is not there.
They list.
Any day subject to your lordship.
Let me first add it.
Very
yes.
May I permit to mention one of the 5 matters. These are all new matters. However, these matters was filed prior puja vacation, and they, that time these were already included in the list. But
they are not in the list.
No, now not now.
My lord, may I be permitted to mention one matter, my lord, for year 2024. This is a motion matter. The matter could not be heard due to the paucity of due to change of several time change of determination, and this is a 10% matter. What happened, my lord? I have challenged the adjudication order on the year of.
Give it. Yes.
Your Lordship, may I be permitted to mention item number 323 of today's cause list, Your Lordship. Your Lordship, the writ was filed in the month of July 2025. Your Lordship, we have challenged the show cause notice dated 9th of June 2025. Your Lordship, during the pendency of the writ petition, the order in origin has been passed. Your Lordship, we have challenged the show cause notice on the grounds that first there was a bunching of bunching of financial years in the show cause notice. Second, Your Lordship, the state has already subject matter is already under adjudication before the state. So it is in violation of provisions of section 62B, Your Lordship. And they have invoked the provisions of section 74. Your Lordship may kindly take up.
Lordship, may I be permitted to mention extension of interim order of 2 cases?
Yes.
Your Lordship, may I be permitted to mention item number 262 also? Your Lordship, this pertains to condonation of delay, Your Lordship. I've served notice upon on this side. Grateful, Your
My lord, may I be permitted to mention, my lord, one matter. We have approached before this court, my lord, against the appellate authority of advanced ruling. The matter is listed last on 1st September 2024 before Justice Rajabasu Chaudhary. Now the department insisting for payment of dues, my lord. That's
Give
it.
it.
My lord, another two matters, my lord. I have mentioned before your lordship in the previous week for SOD leave, taking leave of SOD.
It appeared you
Appeared, my lord, without instruction I have appeared, but now I am having the
give
instruction.
it will appear. The settlement of dispute matters you have you indicated, they will appear under the heading urgent motions.
Your Lordship, may I be permitted to mention one matter for restoration, Your Lordship? I have mentioned it earlier also, and it was accepted, but it was not under
The restoration here.
Lordship, may I be permitted to mention a matter about notice, Your Lordship? It's a 2016 writ petition, Your Lordship. The urgency here is, Lordship, there were
2016 writ petition for hearing.
Lordship, there were two CAD applications in between of 2025, Your Lordship, and
No, if it is a 2016 writ petition for under which group?
should be income tax, Your Lordship. Your Lordship, the urgency in this matter, Your Lordship, there was a group, a batch of writ petitions. Now, those writ petitions were decided and heard on merits and decided, and thereafter it was challenged before the Supreme Court. Now, the problem was this was one of those writ petitions, but for some difficulty in some default, this matter got dismissed for default. Your Lordship, this is a very small point to be decided on, Your Lordship, and there was similar judgment, while based on which the other petitions have been dismissed. If Lordship would kindly include this in the list.
Give it, we shall see. এটা দেখুন কি আছে application heading এ তার ফাইল গুলো একটু দেখিয়ে নেবেন।
Permitted to mention, Lordship, a correction in the order dated 8/1.
What is the mistake?
Lordship, a typographical error. Lordship, it, instead of 8, it has been written October 28, 2020.
Give it.
Lordship, will it be in the
Yes, yes. To be mentioned for correction.
grateful, Lordship?
Yes. চলুন দিদি, list করুন।
Item number 1.
One, my lord, only one correction, my lord.
Yes.
Like 107, instead of 106, third line, my lord.
Third line?
First, second para, third line. It's written 106, it will be 107. Only this correction.
This matter has been mentioned for correction. Now, this matter
My lord, item number 2, my lord, I beg to appear on behalf of the petitioners, my lord. Lord, this is appearing under the caption heading for dismissal.
Yes.
My lord, it's better if I may, my lord.
Mr.
My lord, it's better if your lordship takes it up anytime tomorrow, day after, my lord. We've just received instructions from my lord Bombay. It's just gives us this week, my lord. We'll come back, my lord, next week. If it comments to your lordship.
Very good. Mr. Chatterjee, learned senior advocate appearing for the petitioner, requests for some time to take appropriate instructions, full stop. As requested, comma, list this matter on January 20,
Very well, ma'am.
2026. Next week.
My lord, anytime.
So grateful,
January
so grateful. So grateful.
Grateful, my lord. With your lordship's time.
And I am appearing on behalf of state, my lord.
Madam, I am appearing for the corporation.
My lord, in item number 3, my similar matter is pending before the appeal matter is pending before
Very well.
the Honorable
You are
Justice
appeal for the petitioner.
Corporation.
You are for the petitioner.
Corporation, Bidhan Municipal Corporation.
None appears for the petitioner. Full stop. The petitioner remained unrepresented even on January 2, 2026. Full stop. The matter is appearing under the heading for dismissal today. Full stop. Since the petitioner does not appear to be interested in pursuing its cause, comma, WPA 4574 of 2025 stands dismissed for default. No costs.
My lord, similar matter is there before your lordship. Similar matter.
Similar matter, he has not appeared here, it's being dismissed for default.
Deeply obliged, my lord.
Your Lordship, I am led by Mr. Ramesh Kumar Patodia. He is joined virtually.
Lordship, I am appearing for the petitioner, Lordship.
Yes.
Actually, Lordship,
Who is appearing for the other?
Lordship, here I have challenged a notice which has been issued to a company which was merged into me, Lordship, in the year 2007, Lordship. And upon merger, I had informed the assessing officer that I have been merged and my PAN number be cancelled, Lordship. Moreover, I had also informed the director systems also that I have merged and therefore my PAN be cancelled, Lordship. In spite of that, Lordship, it was not done, it appears, Lordship. And I was issued a notice under section 148 AB of the Income Tax Act in the name of the company, which is not in existence, Lordship. Upon receipt of the said notice, Lordship, I had made a detailed submission.
My lord, no, my lord, there is such, my lord, there was a merger and thereafter there was a demerger.
No, Lordship, there
Yes,
was
yes,
no
that is recorded
demerger.
in the order.
Lordship,
And they have
there is
filed
no
their return.
demerger.
For assessment. Lordship will kindly have a look at the
Lordship,
order.
there is no demerger.
Yes,
Just
yes.
a minute. Let him complete.
Lordship, kindly refer to page number 219 of the writ petition, Lordship. Page number 218, Lordship. The assessing officer records that I have been merged, Lordship. That is known to the assessing officer, Lordship. Page number 218 and the relevant para, page 219 7B, para 7B, Lordship.
218.
219, Lordship, para 7 within bracket B. Lordship, the assessing officer says, moreover, on close analysis of the explanation offered by the instant assessee, wherefrom it is deduced that Bengal Tools Limited was merged into Srachi Leathertechs. Lordship, the notice has been issued in the name of Bengal Tools, and he acknowledges that it was merged into Srachi Leathertechs, Lordship. Then he says, and from Srachi Leathertechs was again demerged to Bengal Tools. That this is not correct, Lordship. This is incorrectly recorded because I have given the details in my reply that what happened, Lordship. I will explain before your Lordship. The notice was issued in the name of Bengal Tools, Lordship. Bengal Tools was merged into a company called Srachi Leathertechs Private Limited, Lordship. And the copy of the High Court order is there in the petition, Lordship. What happened, the High Court order is at page number 46 of the writ petition. Lordship, kindly refer to page 46, Lordship.
Page 46, yes.
Lordship. Lordship, page 46. The Lordship sees that the scheme of amalgamation Bengal Tools Limited, Srachi Engineering and Industries Limited with Srachi Leathertechs Private Limited, Lordship. And the transfer date is recorded as 1st April 2007 in serial number 5, Lordship. And Lordship sees page number 65, Lordship. Page number 65.
Page 65.
Yes, Lordship.
Yes.
Lordship, page 65 is my information which I had given to the assessing officer, where I have informed him that I am amalgamated with Srachi Leathertechs Private Limited wide order dated such and such, and I requested that the PAN number such and such be cancelled. This is my application to the assessing officer. Next page is the information which I had given to the income tax officer systems Lordship Aikar Bhavan, page number 66. The same was there. That is next page, page number 66, Lordship.
Yes.
So I had informed both the assessing officer as well as the income tax officer systems Lordship. Now
Yes.
Lordship comes to page number 62, Lordship.
62.
Yes, Lordship.
Yes.
Lordship, the page number 62 is this Srachi Leather Techs Private Limited, into which the Bengal Tools Limited was merged. The name of the company, this company was converted into a public limited company. This is a certificate that the company has been, the name has been changed to Srachi Leather Techs Limited, Lordship. This is the change. Now let's, Lordship, next page, that is page number 63.
Yes.
The name of this Srachi Leather Techs Limited was changed in the year 2008 to Bengal Tools Limited. And finally, Lordship, in the next page, that is page number 64,
yes,
the name was changed to BTL EPC Limited, who is the petitioner, Lordship, here. So, Lordship, ultimately, Bengal Tools Limited is not in existence. I am the petitioner who is in existence, Lordship. But in spite of, and all these facts were brought to the notice of the assessing officer. However, he has not acknowledged these, Lordship, and the order under section 148 AD was passed.
There is one problem, Mr. Patodia.
Lordship.
After amalgamation, the name of the entity only changed to Bengal Tools.
No,
And
Lordship,
then
the CIN number is the identification, is the in the Companies Act, the identification is through CIN number and PAN number, Lordship. My PAN number is different from the company in the old company whose PAN number was different, Lordship. Because Bengal Tools Limited, in whose PAN the notice has
yes,
been.
I've got it. If once it is amalgamated, it becomes a different entity.
Yes, Lordship, that
The
is my humble
amalgamated
submission.
The amalgamated entity becomes a different entity. It may have been rechristened in the same way. It may have had the same name for some time, and then again it has got a different name. And
That
its
is-
character also changed from private to public.
That is my humble submission, Lordship. And I am relying on a decision, Lordship. There are catena of decisions of Honorable Supreme Court also. I have got a decision of Honorable, my junior will place before your Lordship. There is a decision which I have got, that is Delta Electronics India, which has analyzed the law in the subject, including the decisions of Honorable Supreme Court of India. And there are Calcutta High Court decisions also in this regard, Lordship. So in my respectful submission, the notice having been issued in the case of a company which is no longer in existence, the proceedings are bad in law in my respectful submission, Lordship.
Yes, Mr. Dudhuria.
So Lordship will kindly see.
Because
yes, I have understood.
There is no question of demerger here.
But my lord, using relevant assessment year is my lord 17-18, financial year 16-17. Using this PAN, my lord, 1 crore 22 lakhs was deposited. That is categorically 7.C. Lordship will kindly see. Order 7.C. Page number 219. Page number 219.
219.
Page number 219.
Yes.
Yes. Lordship will kindly see. Then, however, fifth line from bottom, from top.
Yes.
Then, however, SSC Bengal Tools Limited utilizing the PAN for depositing an amount of rupees 1 crore 22 lakhs such and such cash bishop is withdrawal of cash of such and such account during the financial year 16-17 during demonetization period. However, the SSC Bengal Tools Limited was illegally utilizing the PAN towards foreign remittance as well as receiving interest under section 194 capital A during the financial year 16-17. Thus, the transactions undergone by the instant SSC in the account of an entity which is not existing in the eyes of the income tax officer, as the SSC himself has submitted this, hence the falls under the ambit of suspicious, and in view of the fact that it is amply clear to say the SSC Bengal Tools Limited was existing during the year under consideration, carried out a, this is not running the parallel business to hide the entire scheme of the business activity, though it was not existing in the books of the ROC, the income tax department, as well as the police SSC. So categorical finding.
Yes, Mr. Patodia, what is your answer? to this?
Lordship, upon receiving the notice under section 148 AB of the Income Tax Act, Lordship, I have given detailed submissions, including the fact that all these transactions have been duly incorporated in the audited accounts of BTL EPC Limited, which is the petitioner, Lordship. This has happened because the PAN number in the account Axis Bank was not changed by the Axis Bank, even though I had submitted the KYC, fresh KYC I have enclosed in the petition, Lordship. It is at page number 180 and 181, Lordship. So, and that probably they have reported this to the in their returns which they have filed. But all these transactions have been incorporated in my audited accounts, Lordship, and I had produced my entire details, including the bank statement with Axis Bank. Everything was produced before the assessing officer, Lordship. The submission is, I have made the submissions twice, Lordship. The first submission was made, it is on 12th of
Where is that submission of yours that you had?
Lordship, kindly go annexure P6, page number 72. Page number 76, Lordship, page number 76.
76.
Yes, Lordship. Lordship, page number 76, the submissions starts and the para number 6 on next page, Lordship, page 77. Copy of ITR of assessment year 2017-18 and audited accounts are attached herewith at annexure 5 and 6, wherein all the transactions flagged by you have been included, which is being assessed by you only. Next, para 7, without prejudice, I am dealing with the issues raised by you in the notice under section 148 supra listed at serial number 1 to 5 on page 2 of the notice, where you have stated to be available in taxpayer annual summary profile view. And there I have explained in para 7.1, 7.2, 7.3, 4, individual paras, Lordship, I have explained all the transactions and given the evidence also, Lordship, including the copy of the bank statement and the copy of the audited balance sheet, Lordship, and these transactions are duly disclosed and reported in my audited balance sheet, Lordship.
Mr. Dudoria, how has this been considered? All of this?
Lordship, they have not been considered. In fact, Lordship refers to page number 151 of the approval order sanction which has been given, Lordship. Sanction records that I have not made any submission and I have not been given personal hearing, Lordship. The sanction order records that. And in fact, I had...
Page 223.
Page?
223. Serial number 15 and 16.
223, Lordship. Whether any reply was received from the SSC? No.
Reply was
reply was considered. Page 216. I don't know. SSC replied it to 20. It was considered. Order.
Very well. You come back tomorrow. I have considered it.
No, not tomorrow. Day after tomorrow. Tomorrow not.
Very well.
Third.
This writ petition lays challenge, lays challenge to an order dated April 30, 2024, passed under Section 148 capital A within bracket D of the Income Tax Act 1961 and the consequential notice under Section 148 of the said Act of 1961. Full stop. Paragraph. Mr. Patodia, learned advocate appearing for the petitioner, submits that the very initiation of the reassessment proceedings is bad in law in as much as the same has been done against a non-existing entity, in respect of a non-existing entity. Full stop. It is further submitted that despite the petitioner having submitted detailed replies to the notice to show cause issued under Section 148 capital A within bracket small b of the said Act of 1961, none of the replies have been considered by the assessing officer while passing the order impugned. Full stop. Mr. Dudhoria, learned advocate appearing for the respondent revenue authorities, submits that the order impugned has been passed against an existing entity in as much as Bengal Tools Limited, which first got amalgamated with Shrachi Leathertex Limited, was again demerged therefrom, and as such the notice has rightly been issued in the name of Bengal Tools Limited. Full stop. Paragraph. Heard learned advocates appearing for the respective parties and considered the material on record. Now considered na kare, respective parties. Full stop. List this matter for further consideration on
Day after tomorrow.
Day after tomorrow means 15.
Yes, or any other day, but tomorrow also.
On January 19th, 2026, as prayed for by Mr. Dudhoria.
Grateful
19th.
Lordship. Grateful Lordship.
Grateful, Your Lordship.
Eight are
Lord, I'm sorry to trouble your Lordship, Lord, your Lordship is assigned the bench of Justice Kapoor. Lord, urgent declaration, I think Lord has come to your Lordship. But there's a Lordship would indicate not when we can mention or not. We just wanted a matter to be for extension of entry model to be listed as to be mentioned tomorrow, whether before your Lordship or his Lordship, not wherever.
You can mention it now, not a
Lord,
problem.
may I just not hand up to the
Please
entry
give a
model?
notice to the other side.
Yes, Lord, upon notice, Lord, I
Yes,
mentioned.
please.
May just appear.
Extension of interim order, it will appear in the list tomorrow.
Tomorrow, Lord, whether whichever bench Lord is taking, let me as to me. I'm grateful to Lord. 37. Yes.
Yes, that you can do. That is the procedure that we
Yes.
follow.
Please inform us so that we can also see that. If we can.
Not I appear for this statement. But today I'm handicapped with the actual report. I have a scanned copy with me, but the main part, which will help me, is not with me today. But I can, he can proceed and I can show up the report. I have that.
No, it won't help then. We can have it on a different day then.
Tomorrow.
Can we have it tomorrow?
Tomorrow. My entire bag I have left at home.
Not a problem.
Sir.
I'm making it not today simply then.
Yes, my lord.
Tomorrow. এটা দিয়ে দেবেন। ফাইলটাও দেবেন। What was the matter?
My lord, I supplied medicines to the health department of government of West Bengal and I raised invoice accordingly. But I didn't get the full value of the invoice. My lord. There was a deduction of more than 10 lakhs. So that is the issue. My lord. I am praying for.
And what does your report say?
My report says I have paid. There's an order passed by the High Court. They have moved before the High Court. The High Court has directed me to pass a reason order.
he passed a reason order directing the other authorities to give me the calculations whether there is a contract. The tender says that within stipulated period you have to complete the process of the work order. He fails to complete. Then my lord, I asked for a report whether he has
It's a
failed or
group
not.
photo,
No, my lord.
Assign. Very good.
At me and blood them blood I could not survive blood that fixed deposit is only my problem. They have already thrown out blood me from my own house, and I am sad is the main. Only blood the interest of the fixed deposit also. If they want, we are willing to give.
Where have you mentioned that in the writ petition? What is your case in the writ petition?
Blood, your lordship, kindly see the prayer portion. Prayer, page 15, your lordship.
Page 15.
That page 15, okay, page 40. A duplicate B.
That is what I'm saying. You are wrong in what you are submitting, sir. Prematurely, you want to withdraw.
Yes, yes,
that is my understanding of the operation of fixed deposit.
Now,
Premature. How will I direct the bank to you to part with the entire sum in favor of your client? How can that be? If it is a joint,
We can only issue a duplicate certificate of fixed deposit.
whatever is the manner in which you can do it, you can do it. If it is either or survivor mode, then in that case you can withdraw it prematurely.
No. Your lordship can see second thing is prayer C. They issue a duplicate, then prayer C he can they can consider this my representation.
That they will
So that
definitely
they can,
consider.
yes.
They will definitely consider. Yes, madam. What is
My
your
lord,
say?
my lord.
They are your parents. Why are you not?
Yes.
I admit they are my parents.
Then why? What is the problem in even, madam? Even if for the time being, I assume that they are taking something more than what they are entitled to in law. How is the son aggrieved by? Then why is the son contesting?
Mother and father, and moreover the sister. The sister is the what I
Not
say,
in the picture. Not in the picture. Lordship kindly see.
Please wait.
The sister is the key in this matter, my lord. Sister is willing to grab all this. Where from the money has arrived. The father stopped handling business since 2001 when he was appointed by the first private placement. Then placement has changed in 2011
Then Westmoreland again changed in 2021. Father had stopped handling business since 2001. The son is handling this business since 1990. He has given his all the young age minor. Now he is 55 years old. He is having a 18 years daughter student, 12 years son, class 6 student. My lord, I want to show my lord page number 4, para 4. Which the first is 3601 petition, my lord.
Page number 4.
Para 4.
Para 4.
The petitioner received from her husband a large amount and also gave the amount by way of sale of her father's property. My lord, this father's property has been sold in 2020, my lord. Where from this my lord, I want to submit that the way of sale the father's property, Mrs. Deepti Ghosh has received, my lord, amount of
That is
49 lakhs. I know, please let me submit.
that is her own.
49 lakhs, 49 lakhs, from which the deed has been made for rupees 6 lakhs, only 6 lakhs. And entire amount she has received is black money, as black money. She has sufficient money, my lord, to survive. It's the daughter of this petitioner, both the petitioner's daughter, the affidavit portion, my lord, affidavit done by Nitu Ghosh. I am the daughter of the petitioner, and as such, I am well according to the facts and circumstances, but not duly authorized. The next thing, my lord, I want to submit.
Madam, these matters, how are they relevant here? I don't understand. They are irrelevant. Irrelevant absolutely for the purpose. You are leveling allegations against your own mother. You are leveling allegations against your own father. Court is not going to take this in good humor. It's not right. Whether it was her own property, whether she has sold it for 1 crore or 1 rupee, how are you concerned?
Nothing. But this.
So what? If he has nothing, therefore he will ensure that the father and mother also have nothing. Is that the meaning?
Father and father, all principles on the name of the son also. Not only in the name of the father and mother. The son is also a joint depositor.
So the son will walk away with the entirety of it. Then?
He has not taken anything.
So he is not supposed to take anything. He is not supposed to take anything.
He will not take, my lord. But these false allegations against the son is not also right, my lord.
There is no false allegation. What the fathers and mother and father want is that they want their fixed deposit and they want their money in the fixed deposit. Where is the problem for the son in that?
The son is also a joint depositor, my lord.
The son will get whatever the son's share is if he is able to prove that.
May I submit one thing?
A previous occasion, my lord,
May I submit one thing?
Please wait.
Also showed, my lord, this FIR. And this FIR is written content also written by the.
I'm not going into that. FIR and all that I'm not concerned. I'm only concerned with the fixed deposit. Fixed deposit, the bank is willing to issue a duplicate receipt. I will accept the contribution of the bank. You cannot stand in the way. Even if you stand in the way, the bank is willing, the bank will give. Your standing in the way will not prevent them.
The son is not standing in the way. Since the.
Where is your representation? Where is your representation?
Not here. Page 34.
34, not 35.
35.
Page 35 for Deepti Ghosh.
Page 35. May I submit one thing? Page your lordship, see page 25. That it is their submission that in a criminal case.
What is their submission?
Your lordship kindly see bottom. Learned advocate for the accused submitted. Accused means that the son.
Yes.
That the allegation is a household dispute and the accused has filed one undertaking stating that he will not raise any obstruction in assessing the property of the de facto complainant at his home home house, even he himself cooperated de facto complainants to get her property at the instance of the IO and finally praised for granting. Property under the Maintenance Act, property means not immovable.
The writ court will not decide all that. I am directing the bank
Yes.
to issue a
that-
duplicate certificate since the bank is agreeable and your representation will be considered in accordance with law.
Great.
If you are entitled to premature
Or yes.
Payment on the fixed deposit, the bank will make
Yes.
in accordance
Yes.
with the with law. लिखे नहीं.
We just we get paid.
This writ petition has been filed. This writ petition has been filed. Yes.
My lord, last hard on 6 January, my lord, on that date, I have submitted that I have challenged their rectification order in appeal, appellate order, adjudication order. And last day, my lord, also submitted that the allegation, there are 3 allegations. Allegation number 1, allegation number 2, small amount, admitted in appeal. And allegation number
That
3,
I remember.
that is
You,
dropped.
the problem was here. You come to page 222.
Yes, my lord. I have also prepared, my lord, to assist your lordship. One
You come to page 222.
222.
You
Yes,
first
yes.
understand my problem and then you answer.
Yes, yes. Yes, my lord. 222, my lord. That
Yes,
before the last para, my lord.
Your zero rated supply.
Yes.
It was to the tune of rupees 2,22,74,656.
Yes.
Instead of that, you had mentioned 1,95,57,845.
Yes.
So this was falling short by 27 lakh and odd. So this the authority has found that since instead of mentioning 225, you have mentioned 195. Therefore, there is a shortfall of 27. On this, you are supposed to pay tax, and that tax he has calculated. So where is the mistake?
My lord, mistake.
That is the question.
Yes,
which
yes,
I
yes,
want
yes,
to
yes. Your lordship. Yes. My lord, my lord, I'm just giving, my lord, to assist your lordship, short form. Coincidence. I'm giving also one copy my senior. হ্যাঁ copy দিয়ে দিচ্ছি তোমাকে my lord, first line, my lord, I have written this is the nature of business. Second is, my lord, 12%, not 18%. In third, my lord, A, B, and C, my lord. That allegation 1 and 2 nil. Now the fourth allegation, my lord, in the appellate order, page 223, your lordship.
That you don't need to repeat.
Modify to
That
nil.
is not
Yes,
the
yes.
problem.
Modify to
The
nil.
problem is here.
Here, yes, my lord. Then, my lord, next chart I prepare. Then, my lord, page 2, last chart, my lord. Page 2, last chart.
Yes.
The respondent number 3 passed the 107 demanded tax on rupees such and such, and on their show cause notice, this show cause notice and adjudication not expired. This allegation are not there in the show cause notice or in adjudication order.
Allegation of short payment was there in the show cause notice.
No, my lord. That is I will show. Yes, I will show from my lord.
Yes, it was there. Tax short paid was there in the
No,
short
that
paid.
on different point. I will show you, lord.
No point. Short paid is short paid. Whatever point it
No,
is.
my lord,
What
that is
different
different.
point?
I am showing, my lord. I am showing. So, my lord, I prepared this chart. The pre-GST export sale 49 something actual. The post-GST export sale 195 actual. Number 3 export sales 244. This is 1 plus 2. This is actual. And number 4 only GST period. This is wrong figure mentioned in 3B returns. Now next point 5.
How can these facts be gone into at the
No,
stage of
no.
without affidavits, my lord? How these facts, my lord, 9C, 9, this has to
My
be
lord,
scrutinized.
my lord, my respectful simple submission is that these allegation of the ignorance of turnover actually does not exist, and it is not mentioned in the show cause notice nor adjudication. I will show you, lordship.
It is not enhancement of turnover at all. You yourself have said that instead of 222, you have mentioned 195. So that means that there is a shortfall of 27.
No, that is I rectified in the annual return. That position I have rectified.
If you rectify in the annual return, it means there was a shortfall. On that he has
no shortfall, my lord. That is the clerical mistake. That in the read petition para 18, my lord, I have narrated all this fact, my
Your
lord.
sales were not to the tune of 2 crore and odd.
No.
Your sales were only 1 crore 95.
No, my soul is, my lord, 2.44, my lord, total. The 1.1 and 0.2 and addition total, my lord, summation is 244. This is correct, my lord.
Your export sales, which you have mentioned as 195.
Yes, this is correct.
195 is the only sale. 222 is wrong.
220 is wrong. That is I mentioned in my submission also, in grounds of appeal also I have mentioned. Sorry, in the read petition para 18 I have mentioned.
Sure.
Yes, my lord. And these allegation sorry.
Before lecturing, please show the paragraph.
My lord. Starting, my lord, page 12, my lord.
Page 12.
12, my lord. Para 18, my lord. Para, yes. Chart also.
Page 18.
18, page 12.
Page 12.
12 of the reason, para 18, last para, my lord.
Yes.
May I read, my lord?
This you have written. Where is the explanation that is wrong? Where is that?
Yes, my lord, in the page 13, my lord.
Show me that. Why are you showing
yes,
me something which I don't want
my
to
lord,
see?
in the financial year, last para, my lord, in the financial year 17-18, first file return 3B monthly return and GSTR 1 quarterly basis. In the first month of July, this is the first period of July, my lord, the GST period, my lord. When your petitioner filed 3B, taking one export invoice number such and such, dated 30th June such and such, value of rupees such and such on the basis of shipping bill dated 4th July. So, my lord, that amount already submitted in the incorporated in the June. When by mistake also submitted in the month of July on the basis of shipping bill, but invoice bill, my lord, June. That is, I rectified in the annual return. And another inadvertent entry was made in 3B September.
Where is that figure? I don't find in that figure at all. This 220,274. Where is that by mistake? Where have you written that? I don't find it here, even in your submissions.
That is why today when I
in paragraph at page 13, where have you mentioned that this 220,274,656 was
in that
wrongly
table,
mentioned?
my lord. In the table I incorporated, my
In
lord.
the table, I don't find that it was mentioned wrongly. You say that export sales as per GSTR 3B is this much.
Yes, yes, that is correct. That is why, my lord, that this chart is prepared today, my lord.
This chart also does not clarify anything, whether which is wrong, where it is wrong, how it is wrong. How do I get that?
I have marked, my lord, in the bold, my lord.
Yes, in the bold you have written what? It doesn't make any sense.
My lord, this is the very deep of the calculation, my lord. That first one, para number 1 and 2 is correct.
29, he has given some explanation, para 29.
Of the petition?
Yes. But what
Yes.
is the mistake he has not explained?
Para 28 and 29. 28 also, my lord. এই portionটা
28, why are you showing? 28 is
Sorry,
something which
29.
is there.
29.
Unnecessarily, you are always confusing the
29.
code.
29. And difference value at the state of the turnover.
Para 30 is your answer.
Evaluated supply document 3 with 9 as per books of accounts ought to have considered figure reconciled in the annual returns. Yes, ma'am. Para 30 also.
Para 30 is the answer. So unnecessarily, you are taking me to paragraph 28, this chart, that chart.
My question is, my lord, whether 9C was produced before the court, before the authorities.
No, yes, yes, produce.
Well,
Produce. And my humble submission that this point, kindly have a look in the adjudication stage, my lord. This allegation was not there in the show cause. That is why, my lord, here in appellate authority, that section 107(11).
Which allegation was not there?
This allegation, my lord.
Which allegation? Tell me which allegation.
Kindly have a look, my
This
lord.
allegation means what? They will say short paid. What else will they say?
No, my lord. Kindly, my lord, have a look at page. Now, show cause as it is not clear, so I am, my lord, requesting, my lord, to come at page number 38, my lord.
38.
Yes. Because they have made their scrutinized figure of the returns, my lord. 38, my lord. The point number 1. Lordship got, my lord, page 38.
38.
This is, my lord, prior to show cause, the intimation, DRC01 annexer. So the point 1, my lord, 39,884, I admitted. Next, my lord, 39, page 174975, this allegation I admitted, my lord. Next, my lord.
I have cleared. Why are you unnecessarily?
No, my lord, I'm coming, my lord. I'm coming. Then, my lord, 42, my lord. Then page 42. Otherwise, my lord, from my part, my lord, incomplete submission, my lord. Para point number 4, my lord. ITC found reversible if availed. So allegation is ITC related, not turnover related. Now, my lord, 4E. I am drawing, my lord, 4E. Yes. ITC found reversible in proportionate to exempt supply. So this is proportionate to exempt supply 310,119,119. That was modified in appeal 0. And second, ITC found reversible with credit notes. This credit note modified to 0. Now, my lord, this turnover mismatch allegation not there in the show cause notice. And speaking the show cause and also the order is non-speaking. This is violation of 75(6). So, my lord, this allegation, my humble understanding, So show cause notice ought to have issued under section 107(11) to rebut myself. I otherwise, my lord, it was not rebut in the grounds of appeal also.
Yes, Mr. Chakravarti, why don't you reconsider this thing?
Well, we can reconsider.
Reconsider this.
My lord, 107. Second provision.
But my lord, if kindly sees 223, if minor sees the 223, the continuation of that issue, kindly see page 223 of the appellate order.
Page 223.
Yes, my lord, at the end of apology, I start with 222.
Yes.
My lord, this is not adding up to the turnover subject to correction. My lord, it is not a new issue. My lord, if my lord sees the definition of turnover, only the exempted supply is outside the scope of turnover. So, my lord, it is not something that's beyond the issue or beyond. My lord, a person has come.
No, he has also said that this calculation itself is mistaken because actually he had made zero rated supplies to the tune of 1 crore 95 only and not 2 crore 22. So this addition itself could not have arisen. That is his submission if I have understood him correctly.
Yes,
Well, this statement subject to correction, my lord, I did not find in the appeal, and at least the appellate authority has recorded whatever he has.
No, so he could have said this only if the appellate authority had
raised this
confronted it.
question.
He had not raised this question. So in the writ petition in paragraph 30, he says that he has wrongly said so. Paragraph 30 of the writ
Yes,
petition,
my lord.
that he has not considered that. And where is 9C?
Yes, my lord, 9C at page. Starting page 179. Starting page 179.
179. Just
Nine.
a minute. Yes.
Starting page
181.
Starting page 179.
Page 181 is the figure.
181 is the figure. Yes, madam. Yes. Actually, they are taking higher figure.
2.22. Higher figure, where do they get from?
No, they get from GSTR 3B. But I subsequently rectified 1.95.
GSTR 3B, where have you rectified?
Through annual return, madam.
Where is that?
That page 181. C, first line, zero rated supplies without payment of tax.
And where is GSTR 3B?
3B.
You have not annexed.
3B not annexed. Because all the data they are with the portal, madam. Because new point came.
Before this quote, it's not there.
Yes, not there. 3B ache ki dekhun to.
Very well. I'll pass it tomorrow because it will take time unnecessarily.
Yes.
Heard Mr. Rai, learned advocate, appearing for the petitioner, and Mr. Chakravarti, learned advocate, appearing for the respondent, GST authorities. Mr. Chakravarti, tomorrow.
Yes.
List this matter for further consideration tomorrow.
I'm grateful.
কালকে এরকমই রেখে দেন।
হ্যাঁ, I'm good.
এটা রেখে দিন ওর ভেতরে। অর্ডারের কপি আছে, অর্ডার শিট আছে।
এটা রেখে কোন মামলা?
What is this? This is PU matter. Ma'am, I have came before Lordship for the on the violation of principle of natural justice.
Yes, Mr. Chakravarti.
Today my learned friend hand over a copy of the instruction. It seems is untrue. Malad, let the instruction be placed before Lordship. I will place, Malad.
So they have said that you can take back the CPU and the seized documents by
Manan,
making a prayer. You make a prayer.
Manan, let me, Manan,
Unnecessarily, why? If the issue can be resolved, you take it.
malice is apparent. Malice is apparent, Manan. Now, Manan, but when my client Manan came to me, Manan, gave those points on the conduct of the Manan officer, I didn't believe because Manan, I used to Manan appear on behalf of them Manan at point of time. But now Manan, the malice has come out, Manan. Kindly take Manan the second sentence, Manan, from the Manan the fourth line, second sentence of the Manan instruction.
Yes.
Malat, he said, but he never appeared before the proper officer to do so. So, Malat, neither the order reflected that I have not Malat, appeared before the officer. I appeared Malat on the every day before the proper officer. And Malat, if the record will produce Malat, my signature will be, my representative signature will be in on the every day, but I appeared. And when the order says I appeared, they gave me the access to the CPU. They'll give the copy, but the access to the CPU. Now they say I didn't appear, I didn't make an application. Now, Manada, I have a hunch, Manad. Today, Manad, I have a serious hunch, Manad. I don't know, Manad, what will happen. If I, Manad, go to them and, Manad, seek for the Manad, an
It has to
application.
be. How can the court decide? CPU has to be got from them only.
But
I cannot
I
give
know,
the
Manad.
CPU.
I know, Manad. I know. Manad, that is why, Manad, on the last day, Manad, this is before Lordship, Manad, to ask them, Manad, to file a report on this basis. If they file a report with an affidavit, Manad, it will be, Manad, easier for me or for the, Manad, the court.
You file a report.
Manad, only thing this is there one. 72 kindly see.
Yes.
Page 72.
Yes, yes.
Yes.
It's 72.
Yes.
Roman 4.
Roman 4.
RTP has been allowed to access the seized CPU for providing document as sought for in Annexure A for several times. So and so. But neither the RTP produced a document to reconcile the anomalies mentioned in the seized report nor contradict with the findings. This is to mention the RTP can access the CPU and the copy of the seized document application before the proper officer. And this is what is recorded. Minor root italics part, that is what is recorded.
Yes, Manad. But
Well,
I
the
never appeared. I never appeared before him.
Malice.
There's
If
a
it is
question
a
of malice.
question of no, please. If it is a question of malice, then the officer has to be in name, has to be party, better party. My learned friend wants to take the case to that level, there are malice in law and malice in fact. I don't know what my learned friend is actually just simply saying something is in malice, but he has to show. But this I can show other paragraphs where it is shown that the concerned person was given opportunity. He chooses or whatever the language. One question is, today what is the solution? If he wants the information, he goes to the officer and gets the information.
What will happen with this?
I don't know, Manad, because after this one kind of instruction, Manad, the untrue instruction before this honorable court, Manad. But I don't know, Manad, what will happen in his chamber.
This is what is recorded in the order, or
no? That is not in the order. He said I have to file an application. But under the which provision of law I have to file application? I request him in reply to the pre-show notice. But kindly give me this. Before that can't be, and there is no provision in the act. Let my learned friend show the provision whereby I make an application for the seized document.
If he has asked you at the pre-show cause stage, why was it not released then?
This issue is there in the show cause notice also, that he has not been able to reconcile, he did not turn up.
What he is saying, on the
in the pre-show cause notice,
I
he has
request
said
him.
that you give me the documents. Where is that? Show me.
Page 44, my lord. Page 44 is a continuation of my reply for the pre-show cause, my lord.
Page 44.
My paragraph 5. And from the reply to the pre-show cause stage, I have requested, for the content of the CPU, whereby I can reconcile my statement.
I request you to supply me a copy of the seized records and return the CPU. He has made that application.
At the pre-show cause, my lord. That is why, my lord, I am, my lord.
You filed a report.
Yes, my lord.
Why it was not returned despite. Heard Mr. Ghosh.
Lord, item number 10 on the last occasion, it was part heard, my lord. There was a direction to file a supplementary, my lord, adducing certain documents which was not in the petition, my lord. In short, my lord. In short, my lord, DRC 1A was issued. After scrutiny of the return, there were 3 issues, my lord. One was short payment of tax, excess ITC availed, and ITC found reversible. I could not reply as because the notices were in the addition tab, my lord. I'm not into that, my lord. Thereafter, my lord, as per the provision of law 107, appeal was filed, my lord. Appellate authority passed an order, my lord, whereof the first point of short payment of output tax was payment. We had paid, it was dropped. Thereafter, my lord, the second point, my lord, excess ITC availed, my lord, my demand was near about 22 lakh odd, my lord, something, out of which, my lord, presently remains is 1,08,000. That is, I am not contesting, my lord, agreeing, the petitioner has yesterday agreed to pay it, my lord, to reduce the litigation. But my issue is only as regards to reversible of ITC against credit note.
Against?
No, my lord. I'll just produce certain documents, my lord, and thereafter the provision of law, what the law says as regards to this. When there is a credit note, what happens, my lord? If my input tax is lesser than my output tax, my lord, then what happens if there is a negative figure, my lord? Input tax is outer than my output tax is, say, 1 lakh rupees. And my credit is on a higher note, say 1 crore rupees. The return won't accept it. Now, what has to be done, my lord? The law has provided, but basically, my lord, first of all, I'll take your lordship to the supplementary affidavit, my lord, filed, my lord, whereof I'll be establishing that the tax was reversed, my lord. And how? My lord, lordship comes down to page number 6, my lord, of the supplementary affidavit, DSTR 1, my lord.
Page 6.
6. Supplementary affidavit, my lord, handed over right now, my lord. Lordship, come, my lord. GST 1. My lord, column number 4A, 4B, my lord, there, my lord. And thereafter, my lord, serial number 4. Total integrated taxes, my lord, 1,30,635.08. My lord, this GSTR 1 is for the whole financial year. My lord, on the right hand side, 18, 19, my lord, 2018-19. And my lord, the first column, my lord, total integrated taxes 1,30,635.08, my lord. Is it what, my lord? My lord. My lord, this is my total output tax declared under the IGST.
Yes.
My lord. Hereafter, lordship comes down to, my lord, page number, my lord, 11, my lord.
Page number 11.
11. This is for the full total period 18-19, my lord. And this is GST 3B, my lord. 3.1 bracket A, my lord. The total taxable value is 1,36,07,709, my lord. Lordship, got it, my lord?
Yes.
3.1 A, my lord. That is 1,36 lakh is my total taxable value. That is, upon this value, this is my supply value. Upon this value, the tax will be imposed, my lord. My lord. My lord, the next, the adjacent column, my lord, integrated tax, my lord. My lord, it is 1,77 lakhs. My lord, my supply is 1,36 lakhs. My tax cannot be 1,77 lakhs. That means I have added my credit, my lord, the reversible amount to this amount.
To whatever was the tax payable.
Yes.
What would have been the tax? What would have been the tax?
My lord, tax would have been, my lord, 1,30,000, my lord, in GST 1.
Oh,
in 6.
The page 6.
Yes.
This should have been the tax.
This should have been the tax.
So this
the reversible amount.
47,000 and odd is the addition.
My lord. My lord, 1 crore. My lord, 1 crore 74 lakh is near about 1 crore 74 is the addition, my lord. Lordship comes down to, my lord, page number 17, my lord. the tabular, my lord,
Yes, yes, got it.
I've
1 crore,
calculated
it's
it.
1 crore, right? I'm not used to handling big figures, therefore there is a confusion.
My lord, this has been said in the order itself. My lord. The assessing authority has also said this in the order. My lord, page number 17, my lord, the calculation, my lord.
Page 17.
17. But just to demonstrate that this amount has been reversed, my lord.
17.
17. Of the supplementary, my lord.
17, yes.
Of the supplementary.
Yes, yes.
My lord, there is a calculation, my lord, statement of IGST, my lord.
Yes.
My lord. My lord, the first is the as per scrutiny of return, my lord, of the main petition 34, lordship opens, my lord.
Yes.
The
Page
credit
34.
no, 34. 34 and thereafter 39 simultaneously.
34.
4.
Yes.
Well, 34. There's a box on the
Yes.
There's a box on the bottom.
Yes.
Well, in that, well, IGST column, well, integrated tax column is 174,45591.
Yes, this is IGST.
That is the third column. Total ITC reversible, my lord. And the breakup on the first and the amount, my lord, it comes from page number 39, my lord.
Yes.
Page number 39, my lord,
4C.
4C, my lord.
Yes.
4C is 4,997.41. That is, my lord, where PO place of supply is not shown, my lord. And thereafter, my lord, in 4F, this 744,0594. My lord, these two adds up to the third column, my lord, of the page number 17, my lord. So you got it, my lord?
It's 17.
My lord, the supplementary.
This comes to 174,45591.
My lord. My lord. Thereafter, my lord, as per GST 3B, my lord. What I have shown, my lord. My lord, page number 73.
It's 73.
Or my lord, in fact, my lord, in the supplementary affidavit, it has been adduced, my lord. Page number 11, my lord.
Page 73 is also there.
Yes, my lord. Same, my lord. For the convenience of lordship, my lord. 177, my lord, 3.1A, my lord. 177, 40264, my lord.
Yes.
189, my lord. This is the 3B. And thereafter, my lord, in page number 6 of the supplementary affidavit, my lord, 1,30,000, my lord, lordship has seen, my lord, just now,
Yes,
my lord.
that you have shown.
My lord. Total ITC to be reversed is 176,09,629.81, my lord.
Where do I get that?
My lord, this is the deduction of, my lord, 177.
No, where, which page?
My lord, page number 17, my lord, supplementary.
Page 17.
The calculation, my lord.
Page 17, yes.
My lord. My lord, 177,40264, my lord, I have shown to your lordship, my lord, in 3B, my lord. And thereafter, 130 is GST 1, my lord. My lord, page number 6 of the supplementary. Oh, you got it, my lord?
Just.
My lord. My lord, page number 11 of supplementary and 6 of the supplementary.
Yes.
Well, this adds up to actual ITC to be reversed is 176,09,629.81, my lord. My lord. As per, my lord, less ITC reversible as per scrutiny of return, my lord, in page number, my lord, 57, my lord. The demand, DRC 0.
Just a minute. Yes, next.
My lord, as per my demand, my lord, 57 of the main petition, my lord.
57 of the main.
There is a demand notice, my lord.
Page 57. Yes.
My lord, this 174.45 592.
Yes.
My lord, this supplementary affidavit page number 17, if it deducted, my lord, have excess deduction made of 1,64,038.07
No, 174.45 592
is to be deducted, to be reversed, my lord,
for 1819 IGST.
IGST.
Yes.
My lord, if we come, lordship, to page number 17 of the supplementary, my lord, the statement, my lord, which I have handed over, my lord,
Page 17.
page 17. My lord, if it is actually reversible, I have reversed 176. To be reversed is 174.
So according to you, excess has been reversed.
My lord, thereafter, my lord. Now, my lord, lordship comes down to, my lord, page number 9 of the 16 of the supplementary, my lord.
Page 16. Of
But,
the supplement.
But 13, my lord.
13.
13. 13 thereafter.
Page 13. Yes.
My lord, this is GST and DST 9, my lord. My annual return, my lord. Page 13 is my annual return, my lord. My lord, column number 4B, integrated taxes to be payable is 130,635. 4B.
4B, yes.
My lord, right hand column, my lord. 130, this is payable. IGST. And liability declared in page number, my lord.
Page number 13.
Annual return. I have declared my output tax liability under IGST of 1,30,000 rupees, my lord.
Yes.
Which was in 3B, my lord, also.
Yes.
My lord. Thereafter, page number 16, my lord.
Page 16.
My lord, column number, the last box, my lord, 9A, my lord.
9A.
My lord. 9A is the integrated tax, my lord. At the top, my lord, detail of tax paid is 178,59,449.00. 449.
This is tax payable.
Payable. I paid. That is paid. Tax paid.
No. A is tax payable.
My lord, on the
Integrated
bottom, on
tax.
the top, my lord, detail of tax paid. In
Details
page
of
number
tax
16, my
paid.
lord.
So the second column is tax payable.
Yes.
Then paid
And thereafter,
through
I paid.
cash.
Accordingly, my lord, I have paid. There is nothing remaining.
Paid through ITC.
My lord.
So the 397 lakh and odd, then 17 lakh and odd, and then 64 lakh and odd. This will add up to 178.
My lord.
So this 178 you have paid.
My lord. Well, this is my case.
And what?
Now, my lord, what the law provision says, my lord. Well, section 42, my lord. The old act, my lord. It has been omitted, my lord. 42(3). Well, I read it, my lord, for your lordship, my lord. Should I hand over?
3.
42 has been omitted, my lord.
Where the input tax claimed by the recipient in respect of inward supply in excess of tax declared. This one?
My lord. By the supplier for the same supply or the output, my lord. Not the output supply is declared by the supplier and is written valid, my lord. Thereafter, my lord, 5. The amount in respect of which any discrepancy is communicated under subsection 3 and which is not rectified by the supplier and is valid return for the month in which the discrepancy is communicated shall be added to his output tax liability. I've added it to my output tax liability.
This was in the year 2022, it was omitted. And when have you done this?
In 1819, my lord, itself?
1819. Yes, Mr. Chakravarti.
Well, this requires some instruction. I'll require some because some kind what I could not understand was subject to correction. Page 16, the details of tax paid, integrated tax. The column is 1 crore 78 lakhs or And my lord, what I see is the payment paid through ITC is 64 lakhs. Through ITC is 64 lakhs.
So far as integrated tax is concerned.
Yes, my lord, because the allegation is in respect of integrated tax itself. But I have to.
Yes,
see-
Mr. Choraria, what is he saying?
My lord, ITC, the state ITC as well as CGST ITC, my lord, can be adjusted with the IGST, my lord. CGST cannot be adjusted with the state tax, my lord. Or state tax cannot be adjusted with the CGST tax, my lord. But CGST as well as SGST, my lord, can be adjusted with the ITC of under the IGST, my lord, liability under the IGST, my lord. My lord, now, my lord, 4, column number 4, 5, my lord, 97 lakh 31,000, 17 lakh 02,000, and my lord, IGST of 64,000, my lord, 64 lakhs, my lord. These taxes, my lord, in the ITC ledger, my lord, I have adjusted, I have deducted it. If these three are added up, my lord, it will come down to 1,78,059, 1 crore 78 lakh 59,000.
Is there any provision which says that this can be done?
My lord,
under what provision it is done? Just for my understanding, I'm saying.
The payment of tax 49.
What my learned friend says, can you see 49 subsection 5, E and F?
Yes,
Man, A, man, 49 5 subject to man 49 5 A man.
A, E and F. A, B, C, my lord. The amount of input tax credit available in the electronic credit.
It says all can be adjusted against.
No, man,
No,
E and F, man, there is a if man sees E, the center shall not be utilized towards payment of state tax.
State and central, they cannot be adjusted amongst each other. But SGST, IGST and CGST, IGST, vice versa, both can be done.
And I have to check this out. Can you give me a
लिखे नहीं. Supplementary affidavit filed on behalf of the petitioner is taken. Next. You have taken the instructions.
In fact, we have not received the instruction ID. And
Its interim order is continuing.
Interim order is continuing.
It's continuing till the end of January.
Your Lordship will kindly place this on 18th of February, Your Lordship. No, this has come as per your order, Your Lordship.
Very well. So let it, he needs more time. I'm fixing it next week.
Your Lordship, next week will be a problem, Your Lordship.
Let it appear. When you have problem, you ask for an improvement.
Malad, 28, Malad.
28.
Because in between, Malad, there was 27 crore, 27.
28th of January. Very well. लिखे नहीं दीजिए. Mr. Bhattacharya, learned advocate appearing for the CGST authorities, requests for 2 more weeks' time
May I please, my lords?
Yes.
My lords, this is that cash seizure matter, my lords. For the sake of
yes.
recapitulation, my lords, I'll just briefly narrate what the
Here, Mr.
sequence-
Dhanuka, order in original has been passed. Why
Has
do you
been
want the
passed.
rich court to take half
Yes,
of
my
it and
lords.
then half of it?
My lords,
before
because
the
they are
criminal?
two separate cause of actions as I had indicated on the last occasion, my lords. One is cash seizure, which is flowing from section 67 of the CGST Act, and another is adjudication order confirming demand passed under section 74 of the CGST Act. Now, my lords, once these are two separate courses of action, and given that, my lords, insofar as the seizure order is concerned, my lords, that can't be challenged as specific provision to that effect under section 121. So therefore, what I have challenged before the appellate authority
Under section 121, what is the
of the
provision?
CGST Act, my lords, kindly take section 121.
Yes. (121).
Yes, my lords. I am referring to serial number B, my lords. So I'll just read it for my lords. Notwithstanding anything to the contrary in any provision of this act, no appeal shall lie against any decision taken or order passed by an officer of central tax if such decision taken or order passed relates to any one or more of the following matters, namely, I'm not concerned with A, my lords, I'm concerned with B.
So
and
it is not appealable.
it is not appealable. And what I've appealed
Very
before,
well, very
So that my respectful submission will be that Caesar does not remain any more Caesar in the eye of law because that has been adjusted against the demand of the department by way of adjudication. Now, when it has been adjusted or whatever has been set off, now whether this Caesar, which has been done previously for 1 year back, subject to correction, the date of the Caesar is
no,
around
2021.
21.
Yes.
Now, in the year 2025, whether your lordship will entertain a petition of a cause of action which allegedly affect the petitioner in 2021. There will be delay latches and other consequential reliefs. Now, when it has been merged by way of adjudication, now when the adjudication has merged and he has filed an appeal in paragraph 17 of your lordship's brief, page 10.
Paragraph 17.
Paragraph 17, page 10.
Yes.
Now, he has filed an appeal before the appellate authority. Now, owing the appellate authority, it is not the case that he has dissected the appeal in two parts. Now, when the order in original
If your lordship will kindly see the order in original.
The page 145, 137 starts.
182.
145.
182.
182.
Malad, subparagraph C.
C.
I order that the ceased cash to be adjusted towards the above confirmed liability of tax, interest, and penalty imposed as per law. Seizing authority should calculate the interest so and so, so and so. So when it has been adjusted, now this is the merits of the case which is arising out of the adjudication order. Now, if he is aggrieved by any part of the decision or the whole decision, well, he has to take up in appeal. These are my respectful submissions.
Well, I'll cater to that. First of all, my lords, I've been able to, or I'll demonstrate that seizure and adjudication are two separate proceedings. And even if the seizure gets dropped or the goods or cash which has been seized, even if they are released, the adjudication shall still continue or can still continue independently. That is number one, my lords. And number two, when he's saying, my lords, because the adjudication order appropriates or adjusts this amount, my lords. So, my lords, I just put a question to myself. Something which was illegal on day one, as in, because, my lords,
Why was the Caesar not challenged?
My lords, why the Caesar was not challenged? Yes, my lords.
4 year
Why the Caesar was not challenged, my lords? I have an answer to that, my lords. Why Caesar was not challenged is because, my lords, what has fallen from my lords relying upon Deepak Khandelwal is that if they are relevant for the purpose of investigation or for the proceedings. Now, my lords, Supreme Court in armor security is held at where the proceedings pertain to or proceedings can be said to have been initiated from the issuance of show cause notice and culminates when the order has been passed. Now, lords, I waited for the show cause notice and order to see whether how they are relying upon this seized cash.
Very well. Show cause notice was also issued.
Show cause notice was also issued. I replied to that.
Then.
My lords, I've replied to that, and I've also.
No, you ought to have come even then. That in the show cause notice you have not been able to show that it is relevant.
My lords, I could have come then, but my lords, that is still a show cause notice. I waited for the adjudication order.
That is
because my lords, Supreme Court says that proceedings gets concluded when the order is passed.
That proceeding will get concluded when the order is passed only if you say that the Caesar becomes part of the proceeding. You say that those are
those are two independent proceedings.
If those are two independent proceedings, then your argument is self-contradictory. If they are two independent proceedings, then you cannot hold this against the other. Then in that case, you ought to have come at least at the stage of show cause, saying that this in the show cause also they have not been able to show
I vote down, my lords. I could have come at the show cause notice stage, as it has fallen from my lords.
Because in fact, in most of the judgments, I don't know if all.
No, so my lords has dealt with this at the stage of order, show cause notice.
Yes, order in original was not passed.
It was not passed. But my lords, what I'm just saying is, or what my humble submission is that, effectively,
once there is a direction by the adjudicating authority, rightly, wrongly, to adjust it with the amount.
Yes, ma'am.
How will the writ court suddenly intervene and I'll be interfering with the
my lord is not required to interfere with the order. My lord is not.
I just interrupt my learned thing. Kindly come to page 163, subparagraph C. This is the part of the show cause notice which he was on notice. Page 163, subparagraph C. That is the synopsis of the show cause notice. It is starting from page 162, paragraph number 4.
Why seized cash should not be
Absolutely, my lord.
This was an issue.
So, my lord, this was certainly an issue. But, my lord, what I'm saying is what
so if your contention was that cash could not have been seized at all,
yes,
then in that case, when the moment this issue was framed, you ought to have come to the court.
But this cash seizure is legal or not depends on whether it has been relied upon in the course of investigation or not. My lord, that
only is what that investigation only will give rise to the show cause.
Yes,
notice.
that investigation will give rise to the show cause notice. Now, in show cause notice, what they say is it is unaccounted cash. It is unaccounted cash on account of.
That should have given you right to come to the court.
I very well, my lords. I could have come at that point of time, but what I am just on to is, my lords, when the cash seizure is illegal, because they themselves say that it is towards unaccounted proceeds towards clandestine.
What is the answer to this? Now they have asked it to be appropriated.
No, my lords, the problem with this is, my lords, kindly envisage a situation. By adjusting this, I have paid 10% pre-deposit. I have availed the appellate route. Now the demand is 33 lakh rupees on insofar as the adjudication order is concerned. I have paid 10%, 3 lakhs I have paid. I should be entitled to auto stay. But this money continues to be lying with them. That is number one. And the effect of this, my lords, kindly
So that you can always approach the appellate authority and say that you cannot appropriate that.
My lords, that is what I'm saying. They cannot appropriate, but that order is not appealable before the appellate authority. I just showed my lords section 121, number 1. And my lords, number 2 is that
no, order of seizure is different. Order of appropriation of the seized cash by the adjudicating authority.
So, my lords, something which
is not within
which is bad at the foundation, my lords. How can they appropriate?
That is why you have to now allowed the appellate authority to become active.
My lords, if they don't have jurisdiction, can they assume even by consent, my lords? My lords, even by consent, I don't think they can assume jurisdiction.
Mr. Banerjee, is there a provision under which this adjustment can be made?
No, my lords, that is because this is seized cash, my lords. This has not been confiscated. This does not vest in the government.
Well, over here, a cash which is adjustable, well, it has been found in the cash has been found. Now, well, rightly, wrongly, now the judicial decisions are saying, and rightly, which has been said that you cannot. Which is not what is not authorized under the act, you cannot undertake the same.
Because in income tax laws, there is a provision which under which you can appropriate.
My lord, same is the
and whatever is there, you have to refund.
You have to refund.
You don't have a similar.
No, my lord, this is seized cash. This is not confiscated, my lord. My lord, how the process happens even in customs, my lord.
But over
the
here,
cash is
in income tax, there is no confiscation. There is seizure and seize.
So, my lord, in customs, this is a case where goods includes cash, and therefore they have the power to seize the cash, and thereafter there is a provision confiscate, in which case it vests with the government, and then only appropriation can happen. Now, something which
here there is no power of
there is no power of confiscation. It is only confiscation of goods or vehicles, which is 130, my lords. Kindly check section 130, my lords. So therefore they don't have the power. And my lords, kindly appreciate one more thing what this order does. My lords, this order effectively debars me from utilizing my input tax credit, which I could have otherwise utilized for payment of tax. So, my lords, I'll just repeat myself. Assume that, my lords, this order is confirmed, my lords. I decide not to contest. Then this order effectively is in violation of section 49(4) also, which allows ITC to be utilized for payment of tax. But these are all seized goods, seized goods or seized things at best. And therefore, they could have only been relied for the purpose of undertaking the investigation. What can be confiscated, my lords? Kindly take section 130. Yes, my lords.
Yes.
My lord is there. Yes. Notwithstanding anything contained in this act, if any person supplies or receives any goods in contravention of the provisions of this act or the rules made thereof with intent to evade payment of tax, or does not account for any goods which is liable to pay tax, supplies any goods liable to tax without having applied for registration, contravenes any provisions of this rule or act, then kindly takes the last portion after 5, serial number Roman serial number 5. Then all such goods or conveyance shall be liable to confiscation, and the person shall be liable to penalty under section 122. Here what has happened is these are at best, these can be the best case of the department is that these can be either be things which have been seized under section 67, my lords, admittedly. Now, if it is been seized under section 67, given that the show cause notice has been passed and order has been issued, which means that the investigation stands completed, my lords, because there is nothing more which, insofar as these particular cash is concerned, they are required to hold on to. So therefore, once the order has been passed, my lords, their authority to hold on to this cash, which can at best be things, does not exist anymore, my lords, and which is why I waited for the order to be passed. Because investigation stands concluded the moment an adjudication order has been passed. Kindly takes, my lords, section 67, subsection 3, my lords.
67.
My lords,
Yes.
has 67 subsection
That
2
I've seen.
was proviso and subsection 3, my lords. So one which is not relied upon has to be returned within 30 days. Which is relied upon has to be kept with as long as it is required for the purpose of investing. The moment an order has been passed, where is the question of I get into the statutory appeal route, and therefore, my lords, I pay 10%. I enjoy auto stay. But what the effect of this order is, the sum of rupees 1 crore 39 lakhs continues to be with the department. I pay 10%. That auto stay I am not enjoying at all. And effectively, the tax which I could have paid utilizing my ITC, my lords, section 49(4) kindly takes once. Section 49, subsection 4, my lords.
Section 49(4).
Yes, my lord.
Yes.
My lords, the amount available in the electronic credit ledger may be used for making any payment towards output tax under this act or under IGST Act in such manner subject to such conditions as may prescribe. Now, my lords, assuming that this demand of rupees 33 lakhs, which has been raised in the adjudication order, I don't challenge it. Assuming, my lords, for a moment, assuming I don't challenge. And if this order is to sustain of this adjustment, my lords, I could have utilized my ITC, which is sitting in my books, as opposed to that, because
this is amount available in electronic credit ledger.
Yes.
What they have seized is cash.
Cash, first of all, they could not seize, my lords. Now they are taking benefit.
So how are you relating this?
So I am relating this to say that, my lords, why this portion of the order, although I have appealed against the merits of the order before the appellate authority, why this portion also I had kind of impugned in my petition is because, my lords, by this portion of the impugned order, which adjusts the cash, first of all, they did not have authority to do that. Appropriation was not permissible because they have no power to confiscate cash, at least insofar as the framework of GST law is concerned. Second, my lords, what is happening is because the cash has been registered against my tax liability, my right to utilize my credit ledger in terms of section 49(4) to pay the tax liability is also taken away.
How?
Because I could have utilized the cash
in the ITC
to make the payment, but they have already adjusted the cash which was lying with them. So effectively kind of denuding my right of availing section 49(4). And my lords, what is the effect of stay, my lords? 10% I have pre-deposited. I get an auto stay. Then what else remains? My lords has also passed orders releasing the bank accounts which has been attached. How is cash different from that?
He has sort of executed the order at the stage of passing of the
Over
ITC.
here, kindly see the observation of the tribunal, which has been made. Well, at page 170.
170.
Well, just a minute. That is not correct. Just a minute. Well, I'm sorry, page 172.
172.
172. Serial number 2.
Serial number 2.
Yes, ma'am.
172.
Well, towards the last paragraph. Last paragraph, serial number 2.
Yes, handwritten sheet of paper.
Well, Rajesh Kumar Mishra.
Yes, 2.
Lordship may kindly. Therefore, my lord, this is on merits the observation which has been made by the adjudicating authority. Now, whether this part of the order has been segregated from the appeal, there is no appeal cause paper before your lordship, including the final adjustment which has been made.
Well, I just showed to your lordship.
Defeats delay is a main ground for the petitioner. He has chosen not to challenge that alleged action. Now, whether the action which is a cause for him to challenge arose in 2020-21 when the seizure was effected. Now, he was He was keeping silent. His only alibi was that I want to see the end of the adjudication process. Show cause was issued. Show cause, he was put on notice that we intend to adjust the same. He did not oppose the same by writing or agitating the same before the appropriate forum. I am not saying which is the appropriate forum. Thereafter, when the adjudication process is complete, well, he did not come before your lordship, but he preferred an appeal.
But whether, Mr. Banerjee, the authorities have right to appropriate or
Well,
adjust,
the merits of the
under which provision?
well, he has done it because the cash cannot be remained as it is. The
No,
cash.
but you have, if the seized articles, there should be a provision for adjustment or appropriation of seized material or seized cash against the demand that you are going to raise or that you have raised. Where is that provision?
Right.
67, as I can see, is a process for collection of evidence. Whether it can be turned into a means of recovery.
May I just
yes,
Lordship, kindly appreciate the facts of the instant case. Here, my lord, search and seizure was done at the premises of the petitioner company, on the ground that there was evasion of tax because they were selling those goods without payment of tax and without proper licit documents, and coupled with the fact there was misuse of the ITC. These are the two basic premises on which my lord proceeding was drawn up. Seizure was made, or pursuant to the seizure made, my lord, their seizure of cash was made. When seizure of cash was made, no challenge to such seizure was made by the petitioner. Thereafter, the investigation culminated into a issuance of show cause notice. Even when the show cause notice was issued, wherein it was heavily relied upon and referred to regarding the cash seizure, no challenge was thrown to that seizure notice. Now they went into adjudication. They faced the adjudication. Adjudication was done. While adjudication was done, it culminated into passing an order against the petitioner. While the adjudication order was done, in the adjudication order, the amount was ordered to be appropriated. Therefore, my lord, the stand of the department that the things that have been seized, that is one thing being the cash, is required and useful for relevant to any proceeding under this act. So this seizure comes within these parameters. That is reflected in the show cause notice and stands vindicated by the order in original passed by the appropriate authority. Now they have preferred an appeal, a composite appeal against said order in original. They have, from the writ petition, it doesn't appear that whether they have preferred an application for stay or not, and whether an order of stay has been passed or not. Therefore, on this day, the order of adjudicating authority is in force. If the order of adjudicating authority is in force, that strongly vindicates the point that the cash that has been seized is required and useful
No, but
for.
Mr. They are not required to prefer any separate stay application if they file an appeal. If they file an appeal upon putting in the pre-deposit of 10%,
pay 10%.
Recovery is automatically stayed.
Recovery is stayed, but
So
can you also seize?
So that is also recovery.
Yes.
Appropriation is also recovery.
But
So
that
also will-
the amount that has already been appropriated will stand till disposal of the appeal. If in the appeal, the petitioner, ultimately the appellate authority goes in.
Mr. My question was on a more basic premise. Where is the authority for you to appropriate? How do you appropriate? Because there is an authority with you to pass adjudication order and to execute the adjudication order for recovery. Now, before initiating recovery proceedings, how can you just appropriate on the basis?
We have not appropriated at the time of recovery. We have seized the.
No, at the time of passing the adjudication
at the time of
order,
passing the order,
you have passed the adjudication order and in a way executed it or recovered at the same time, at the same breath. How is that possible?
That can be justified by the manner in which it has been done. It has been seized first. They were given a chance to reply to it. They have not even challenged the
Then what
seizure.
will happen to the provisions for recovery? Recovery mechanism is to be resorted to after the adjudication order is passed. He is put on notice. He doesn't pay.
And if
then you seek recovery.
Pay 10%. Over here, Lordship kindly sees the distinguishing point. The distinguishing point is the amount which is required to be recovered is already with the revenue in the form of a seizure, which has not been challenged by them. If the recovery amount already stands satisfied, will there be a question or a requirement for recovery further?
Only if the provision, there is a provision which empowers you to utilize the seized sum as first of all, there has to be a power authorizing you to seize cash. If there is a power, you have seized cash rightly, then there has to be a power in the provision in the books which authorizes you to utilize the seized cash against the demand that is going to be raised on you. Now, where is that power? Because in income tax authority provisions, there is a provision in the rules which says that you will appropriate, and whatever is balance, you will return.
My lords, same provisions are there in customs and excise as well, my lords. Which
But
is
it's
why
not there in
they,
the
because my lords, I just put a question to myself: something which has been not been confiscated, how does it vest in the government? And my lords, when my learned friends are saying,
think of this.
Yes, Mal, but I don't. My submission is the amount that has been seized was adjusted with the amount that has.
There has to be power for
Lordship,
adjustment.
let us consider it, and if your lordship
Please
allows
come
us to
back.
come.
my lords, just one thing, my lords, before my lords, with respect to the contention of my learned friend, that this is a delay I have not challenged, my lords. Well, this is a case of continuing wrong. They hold on to my cash till date.
No,
So therefore,
Mr.
my lords,
Madhuka, it may not be a case of continuing wrong, because damage is done the moment it is seized.
yes, it is done, and but they continue to hold the.
damage is complete. Once the damage is complete, your delays. It's not a case. A question. It's not a case where limitation is to set in. It
Right.
is a question where I have to balance equities. I have to see whether you have approached the court with due dispatch, whether you have approached the court with the promptitude the case requires.
Yes, my
Now
lords.
here you may be falling short of the requisite promptitude on your part in approaching court,
My lords.
because the search and seizure action date backs to 2021.
My lords.
Your writ is lodged in 2025.
My lords.
4 years from the date of seizure,
Yes.
you have kept quiet.
Yes, my lords.
You have allowed the adjudication order to be passed.
Yes.
Once the adjudication order is passed, the moment an adjudication order is passed, your appellate remedy becomes active.
My lords, I
Till
paid
such time
10%.
It was not there. Till such time it was not there, you could have said that I am remediless.
Yes.
Therefore, writ court is the only
Yes, my
place where I have to come.
My lords.
You could have come to the writ court.
Yes.
Once you have activated the appellate remedy, your usual course of attack will be to approach that authority and impugn the order.
Yes, my lords.
Now, this is one basic point which
My lords, I'll
which is
consider this,
troubling.
but my lords also considers.
Because here now you are splitting the order into two parts. One part you are seeking to challenge. Now, this court has
My lords,
always discouraged parallel proceedings.
My lords,
This is one of the most illustrious
My lords,
examples of parallel
No, my
proceedings.
lords,
being
I'll
held.
satisfy
This is
my lords.
another
My
thing
lords,
which
because
is-
I
which
had
is
shown my
troubling.
lords section 121. I can't prefer an appeal against the seizure order. My lords, I take your point
Very
that
well,
seizure
it is
order was.
no longer a seizure order now.
It is no. My
It
lords,
is no longer a seizure
because,
order.
my lords,
It was a seizure order till such time that the adjudication order was passed. Now the adjudicating authority has passed an order, rightly or wrongly. It is an error of jurisdiction. All of this will be open to challenge before the adjudicating authority. The adjudicating authority can also say that you don't have power to adjust. I am deleting that part. The moment it says so, it will be open for you.
my lord, but that is not before the appellate authority, because before the appellate authority, I'm only going against the order in original, which contains the demand of 33 lakhs. How can I plead this? Because that is not an appellable order.
The adjudication order itself is under challenge.
Yes, it is under challenge.
Parts of it are under challenge before the appellate authority.
My lords, I very well take that point, my lords. Now kindly basically,
In
my
the
lords,
appellate authority, you have mentioned that I am not challenging that part of the order before you.
my lords, I have not challenged because I could not have. No, I have not mentioned that specifically.
That
but
is why. So the entirety of it is.
no. So I have not mentioned that. I need to
That I
be as an officer. I've not told that. But
So in that case, I don't see a prima facie, of course, because I'll be enlightened by
Yes.
all of you in course of hearing, whether this 121 provision will still hold the appellate authority back from deciding, because 121 says that an order of seizure is not appealable. If it is not appealable, then an extension thereof.
Over here, the order of seizure as it is. Well, my respectful submission will be that when an order of seizure is there, if the order of seizure is challenged before the appellate authority, then the appellate authority loses its jurisdiction. But when the order of seizure merges with the adjudication order by way of the set off or adjustment, it does not remain an order.
Then you will have to satisfy
Where is
that
the-
this set off or adjustment
Yes.
is something which is provided for by the statute.
Well,
Because then, Mr. Banerjee, suppose seizure order is not challengeable before the appellate authority. Now there is no provision by strength whereof.
Seizure order there is a with regard Caesar order over here. The Caesar order has to. Well, I shall take. I shall be.
Because I'll just articulate my question so
Yes,
that
brother.
I can get more educated. First is that if the Caesar order itself cannot be assailed before the appellate authority, and there is no provision falling upon which you can appropriate seized amounts, then in that case, whether by doing that which is not permitted by law or which is not provided for by law, the order which was originally not appealable will be made appealable. You are doing something which you are not authorized by law, you are coupling it with that, and then you say that now you are a full package, you have to go before
this is
the
a
appellate.
classic-
Originally it was not appealable.
No, this is a
How will the extension thereof, for which there is no provision, become appealable? Yes, if you can show that there is a provision under which this can be done, then in that case, for it to become a part of the appellate order, the original order, or for merger to happen, there has to be some legal thing that has arisen, and an illegal thing cannot be said to be, then it will float. For merge, it has to be homogeneous.
Yes,
It has to be part of the same thing. There cannot be a heterogeneous mixture before the appellate authority, something which he cannot do, something which he can do, then that will be difficult. It has to be the same hierarchy. For example, a writ court's order will not merge into an assessment order, or an assessment order will not merge into a writ court's order, because there is a hierarchy of appeal. It will merge in the appellate order, that will merge in the tribunal. That is how this is a separate proceeding. So if Caesar itself is a separate proceeding, adjustment thereof, unless it is permitted by law, whether that will form, this aspect also we'll have to ponder over.
And this would then amount to taking benefit of their own wrong. Assuming that my lords, there is no provision
You
for
first get ready on 4 years.
my lords.
That is the biggest problem.
I will satisfy those.
It's a ticklish issue, but
Yes,
interesting.
it's very interesting issue.
Because section 121 specifically carves it out of the
Caesar
scope of of the scope of appeals. If it is not there, by doing something which the statute does not specifically provide for, whether that can be made appealable. If then there is no appellate remedy available to him, then the writ court will have to intervene, and then you will have to justify your action, and I'll have to check it whether Caesar was proper or not, whether you have done it or not, and other things will come into picture. Because in the other case where Mr. Banerjee appeared, it was very easy, because they themselves had said, I have written it to the income tax authority, you take. So there was nothing which, there was a line that clandestine and all, but ultimately that part where they have referred it to the income tax authorities made things simpler. They are not concerned about it.
And that is distinguishable on fact also. That
Yes, it is distinct, because that paragraph itself was sufficient for me to arrive at a conclusion that they themselves said that we have activated the income tax authority. It is unaccountable. If it is income tax, then it is not for your benefit at all. So it made things easier. Here it is a little difficult. When can we come back? You want to file?
It's better, Lordship, if Lordship allows us to file a short affidavit and
file it. Heard Mr. Dhanuka, learned advocate, appearing for the petitioner.
Grateful. Grateful.
13 to 18 are analogous matters. This was regarding that 75-7. The appellate authority had stated, yes, there is an error in 75-7, but it's a technical issue.
Oh, it was that matter, no?
And in one of the years, my learned friend senior had conducted that another rate was there. I found out, lordships, in that rate, it was challenged on some merits. There was no natural justice played also. That copy I have checked. So, in the interest of justice, lordship, when 6 years, all the 6 years in the second round, liberty was given to file appeal before the appellate authority.
May I suggest this? My lord, I have seen 75-7. My lord, kindly remand the entire issue before the adjudicating authority, the proper officer from the state, and he be allowed to issue a fresh show cause notice.
Lordships, my same prayer.
Without going into the issue of the limitation. That may be recorded. Without going into the issue of limitation.
Limitation means?
Time bar.
Time bar.
17-18 under 73 up to 2021 it has already come.
They will not be allowed to urge.
Yes, but that is what I.
Lordships. And they issue a fresh show cause with all details, lordship, because what I portrayed in the last occasion, lordship, the show cause has certain tables. It is written as per BO portal. But what is the basis of those data? Unless I am put to notice, what can I reply, lordships?
Where is
Lordship, the pre-show cause was at lordship page 44, 46.
The instruction, my lord, paragraph 2, I request my lord to consider. That is between me and the court.
Okay, thank you.
Paragraph 2, my lord.
Next time I will also not be caseless. देवाली सर को पहले दे दिया था, मेरे को नहीं दिया.
कोर्ट का direction.
And where is the appellate order?
Lordship, appellate order starts at page 130. Observation starts at 155. (155) is the observation starts. (155), lordship, up to 155, last paragraph is the observation. Before that is the appeal draft has been extracted. And the relevant discussion, lordship, which I showed at page 159. Lordship, second last para, no doubt it's a violation of 75-7. But as the demand has been raised upon due hearing and considering the books of
New
account,
grounds were considered by the adjudicating authority.
Lordships.
In all the case,
In all same, exactly same.
They are all related to the same year also.
No, lordship, I given this chart, lordship, on the last occasion. This table is before your lordship.
Yes.
Lordship, so these are the serial numbers, lordship, will change. It is like it will be 13, 14, 15, 16, 17, 18. It was on the last occasion given as per that serial number. But WPA numbers is in seriality as per the today's list. So it is 18, 19, 19, 20, 20, 21, 21, 22, 22, 23 and 17, 18. Only 17, 18 has come as last. It should have, while filing it as there was an error by the clerks. Otherwise it should have been filed as first.
Very well. Today it's only 10 minutes before the recess. It will take time if I pass orders.
Yes. You can
I'm
come back.
keeping it tomorrow. Not today করে রাখুন একটু এগুলো দিয়ে দেবেন তো পরে আসবো কারণ এতগুলো কাগজ আছে এখন 10 মিনিটে হবেও না not today করে রাখুন দিয়ে দেবেন হ্যাঁ এটা আমাকে একটু দিয়ে দেবেন তাহলে একটু পড়ে রাখবো পেজগুলো এইদিক ওইদিক হয়ে যাবে সব হ্যাঁ হ্যাঁ না বসে
Numbers of all the matters with appeal order numbers, and I've given the dates. Page numbers also I will prepare.
Give it. Grateful. It will be easier because if I start passing orders in court now, then in
Lordship.
that case others will be held up.
Grateful.
This I have understood. Tomorrow it will be done.
Lordship.
এই কন্টিনিউইং ম্যাটার গুলো নিচে চলে গেল কেন দিদি কন্টিনিউইং ম্যাটার তো উপরে থাকার জন্য কন্টিনিউইং লেখা ছিল তো নিচে করে দিলেন কেন
But let this matter be admitted for exchange of affidavit, my lord, the 16(2)(c), my lord, 16(2), my lord, where is?
You have the earlier order?
No, my lord.
You don't have it?
Sorry, my lord, 16.
No, that would make
Yes,
things
yes.
easier because.
My lord, tomorrow, my lord.
Very good. And not today, Kon.
My lord.
Next.
Okay. Well, here, my lord, the seller has not reflected my supply in his return.
Very well, I'll give it. 10% you will deposit and I'll stay. That is it.
Well, if it is required, my lord, I'll be coming to your lordship, my lord, for the 10%, my lord.
Very well. দেখি দিন করে দিন সব কটা কাল রাখলে হবে না লিখে নিন this writ petition has been filed
In item number 20, my lord, I'm challenging the adjudication order, my lord, on twin grounds. My lord, violation of 75(4), my lord, personal hearing, and my lord, 75 subsection 6, the requirement of passing a recent order. Now, my lord, I'll just briefly indicate, my lord, kindly turns to page 28.
when was the adjudication order passed?
My lord, I had preferred an appeal, it was dismissed on ground of limitation.
Oh, very well. How many days delay?
My lord, 94 days beyond the 4-month period.
What is your explanation?
Well, I say that it was served on the portal. I did not notice. Subsequently, I received a phone call from the department. Thereafter, I preferred. And my lord, the adjudicating authority holds that the appellate authority holds that the service on the additional tab is proper service. Your explanation is not acceptable. On that ground, he rejects it.
Mr. Chakravarti?
I should page down. My lord, would kindly see page 50 last paragraph.
50.
50, my lord, last paragraph.
50 last paragraph.
The reason stated above is not considered sufficient cause for delaying submission of appeal because as soon as order is uploaded, a notification is sent to the registered mobile address, contact number of director.
Right, he says that it automatically goes. He does not say that it has gone. So, my lord, I have a screenshot of the email. There is no service, my lord.
No. When I'll come back with my friend says, because then this is some kind of a
My lord, even otherwise, my lord, there is a
No,
non-speaking.
because they also say that this can easily be proved if SMS history of the above number is checked and the above email ID is checked. So whether he has checked that, if he checks up, then he'll be able to tell that.
My lord, even otherwise, my lord, this is a non-speaking order. My lord, if my lord delegates me to appeal, my lord, I will not be able to pray for a meaningful appeal. My lord, only the summary forms
But he
have
had
been.
preferred appeal.
My lord, in that I have indicated that kindly give me the basis. In appeal, I have
So you get
categorically.
it before the appellate authority. You have preferred appeal against the appellate order only you have
My
come.
lord, appellate authority, my lord, I'll be losing a forum, my lord.
Why will you then? Why did you approach the appeal, the appellate forum? You could have come up directly before this court in writ.
My lord, I was improperly advised at that time, my lord. My lord, in Ram Kumar Sinal, my lord will recall, my lord, it was said that if the appellate authority does not remedy the right of personal hearing, then, my lord, it will be open for the writ court to intervene and set aside the order which was passed in violation of the natural justice.
What is the natural justice violation here in your case?
My lord, he has not given me any opportunity of hearing, my lord, page 28.
Page 28.
My lord, date, time, and when you read NA.
You had filed your reply to the show cause.
No, my lord.
Why?
My lord, it evaded my notice. It was served on the additional tab.
All of that was served on the additional tab.
Yes, my lord. In fact, my lord, the appellate authority has extracted screenshots and produced in the appellate order.
Delhi judgment about
So, Mr. Chakravarti, if nothing was served on him,
Yes,
then
my lord, I can understand that, but order was in the amended portal. Order was uploaded. Order is 26th April 2024. As per the Delhi High Court judgment, my lord, the portal was corrected from the month of January 2024. So if he is aware of, then my lord, he cannot take the excuse that he was not aware of the order.
my lord, but the order was passed without hearing him.
But I understand that, but not in even with that cannot be an issue because he says he did not notice it.
No, even if the order was passed, the adjudication order was supposed to have been served on him. The order was passed without hearing him.
Yeah, my lord, but that
And without giving an opportunity to show cause, because the show cause was served on the unamended portal.
Yes, that.
So he did not have an opportunity to respond to the show cause.
And, my lord, the order is non-speaking, my lord. Only the summary forms have been given. My lord, page 36 in my lord's terms.
Page
36, my lord, of my application.
36.
36.
Yes.
Lord, only the summary table has been given and the calculation.
The order is non-speaking also.
Yes, my lord.
Several grounds. After recess, I'll come back and dictate the order.
Without the issue of limitations.
Yes, yes. Limitation will not be there. I'll come back.
for leave, my lord, of the determination of Honorable Justice Sampa Sarkar, my lord. Since Miss Justice Sarkar's determination is with Justice Kapoor, my lord, and Justice Kapoor's determination is for today is with my lord, my lord. There is a compelling circumstances. I am praying for a leave, my
But the list which has been given to me is only with respect to Justice Kapoor. To get a clarification, because even if I grant leave, that may not be proper.
lord. I am also, since Justice Sarkar's determination was with Justice
Justice
Kapoor, my
Rashidi
lord.
has it. Justice Rashidi will have it. देखिए दीदी के देखिए.
My lord, I tender my apology, my lord.
Justice Rashidi.
My lord.
Yes. नहीं, order नहीं. Where is Mr. Chakravarti? Password করে দিন.
Status. তো সোমেন আবার বাইরে চলে গেল। হ্যাঁ ডাকো ও আবার বাইরে চলে গেল।
He was there. Pick it up. Yes.
My lord, 22, my lord, last heard 23rd December.
22 तारीख. Yes.
Last heard, my lord, 23rd December, that all lordship may remember all the notices in the 148 AD stage, all the notices sent in the old email ID. And much prior to that, I have changed my email address. And learned friend also, the lordship directed to take instruction regarding this, as per last order, my lord.
Yes, Mr. Bhattacharya, I've got your instructions.
Lord, it is true, my lord, Lord, it is the case of the my lord, the department that the notice my lord, uploaded in the portal. It are not sent in the email. Now, my lord, whether the assessee has knowledge, because my lord, he has changed the, maybe my lord, he has changed the portal. But my lord, always, my lord, he can access his portal. And the all notices are in the portal. And now, my lord, from the writ petition, the assessee said that, but in the middle of the assessment year, but he has changed the email ID. And it is his contention that the email address has been changed. Thereafter, in the email, no communication has been made. Now, contention of the department is that the assessee has knowledge, because he has always access, even if his portal has been changed in the earlier portal also, in earlier time also he has knowledge, and because he has access to the his portal. That is the simplicity case of the department. Now let's complete.
No.
Now there is the section 282 and rule 127 of the Act of the rules 127 and section 282 of the Income Tax Act. It says regarding service. And before I place those two sections, I paying before your lordship kindly go through the notification regarding the faceless assessment. It is published in the in 12 September 2019. What it says in faceless assessment. আমাদের ট্যাব থেকে বার করে
ইনকাম ট্যাক্সের বই
হ্যাঁ মিস করে দিচ্ছেন, খোলা আছে এটা একটু বাট বইটা মিস করে দিচ্ছেন।
Give me the copy.
Mala. Now let page 14, page 14, not page 14. Serial number 10, delivery of electronic record. Well, may I read out here? Every notice or order or any other electronic communication under this scheme shall be delivered to the addressee being the assessee by way of placing an authenticated copy whereof the assessee's registered account. These accounts means the portal. Thereafter, or sending an authenticated copy thereof to the registered email address of the assessee or his authorized representative. My submission is before the lordship that this is the Roma B is Milord alternative service. Because the primary service is that placing an authenticated copy thereof in the assessee's registered account. Now, Milord, being the officer of the court, Milord, I must say, Milord, assessee have alternative submission. He may say that service in the portal is not sufficient service. The department has to send to his email also. But here is the case of the assessee that he is saying, I have no knowledge. I have knowledge. We have given a date after a long time. He said, well, department officer called me. I get the knowledge. But in that code of submission, I am opposing. Because he has knowledge. He may say, because being the officer of the court, I must say there is some judgment of the court. It says that the not only portal, the department is obliged to send to the email also. Some line of judgment is there because I am candid before the lordship. But the case of the assessee is that he has no knowledge from the date of calling of the one officer to his mobile. He has knowledge, and if that is so, I am opposing. My submission was in the earlier occasion also. The repetition when the after a long time, when he is silent, having knowledge to the proceeding, he cannot move as when he wished to move to the read court. Now let your lordship kindly see section 282. The income tax. Your lordship having? No, I don't have it.
I also missed the book also.
This is the book. Yes. Now, this service of notice generally the service of notice or summons or requisition order communication under this act may be made by delivering or transmitting a copy thereof to a person herein named by post such and such, be in the manner as approved by Code of Civil. We are not that in form of the electronic record as provided chapter 4 of the Information of Technology Act, by other transmission of document as provided by rules made by the board in this behalf. My lord, I am in D. Now, my lord, D says 127 says. My lord, I am also handing out the book. After I have one copy rules. Service of notice, summons, requisition, order, or other communications. For the purpose of, may I reading and thereafter, for the purpose of subsection 1 of section 182, the addresses, including the address of the electronic mail or electronic mail message, to which a notice, a summons, or requisition or order or any other communication under the Act may be delivered or transmitted shall be as per sub-rule B. Now, the sub-rule B says modes the addresses referred to in sub-rule 1 shall be, but I am skipping. Thereafter, sub-rule have A and B. B says for communication delivered or transmitted electronically, mail, email address available in income tax return furnished by the addressee to which the communication relates. Again reading, email address available to the income tax return furnished by the addressee to such communication relates, or the email address available in the last income tax return furnished by the address. Now, in the last income tax return, the earlier mail was there. In the verge of period, he has changed the mail, and he is saying that in the email the communication has not been made. But the Act rules it specifically says, Milord, the having Milord last return file will the mail. That is the Milord department it can be said that in that mail the department should send the notices. Well, this is my secondary submission, because my submission is that he has knowledge, because it is in the portal, because the writ petition made in the way that he has knowledge from that point of time. It is not said that the department also obliged to send not only the portal to the mail also. And if I made this submission that he has the knowledge from the portal, now if Lordship allow me, then I would read out 2 or 3 paragraphs from the writ petition. Paragraph number 17. But it is also his admission, page 20.
Page 20.
Yes. On the same day, that is such and such, the respondent number issued a notice under section such and such, and this notice only uploaded in the online portal and did not send through registered primary email or any other mode of service. And this notice, the respondent number directed your petitioner to furnish income tax return within 90 days, such and such. But petitioner itself says the notice uploaded in the portal. Now, thereafter he made submission. Paragraph number 22. Thereafter, your petitioner on or about 26/6/2025 received phone call from the office of the respondent number 3 and got knowledge that there is a section 140 notice issued to your petitioner. Now, in the earlier paragraph, his petitioner says it is in the portal, and paragraph number 22, it says from the your petitioner on or about such and such received phone call from the office of the respondent number T and got knowledge that there is a section 148 notice to curtail the limitation. Petitioner knows if the notice has been received 2024 and the frag end of 2025, he should not be permitted by this court of equity under Article 226 to prefer the petition. That is the story, And thereafter, next paragraph, your petitioner states that your petitioner are totally unaware of the income tax assessment proceeding up to the issuance of section 148 notice. Thereafter, issuance notice under section such and such and under section such and such. Thereafter, in that it is also it is submitted. But it is a false submission because of your petitioner totally unaware of the income tax proceeding up to issuance of 140, because in earlier paragraph he has admitted that it is in portal.
Show me the rules.
Rules, yes. Rules, let's start. But it has A and B. So 127 2 A modes and B. Well, I am relying B, B, A, B.
And email address available in the income tax return furnished by the addressee to which the communication relates.
Yes. Now let in the
in this case the income tax return is for which year?
But it is
1718.
1718.
In respect of 1718, the same email was there to which it has been served.
Well, that he has to say.
1718 no return submitted, but after that return submitted.
Now, in paragraph.
No. In respect of 1718, you must have filed your return for that
no,
year.
No, that is why that para 7 and 8 I have stated why I have not filed return.
You have not filed any return at
No,
all
no
for
return
1718.
filed. And 148 notice issued only for the cash amount withdrawn, some amount. That
In
I will
respect
submit.
of 1718.
1718. For cash amount withdrawn, only 1,69 lakh for tea gardens, wages, salary, that I will submit. After
Now, in paragraph number 11, page 10.
Then if he has not submitted any return, then in that case, how will this rule apply?
But then department has knowledge his earlier return having the earlier CR return with the mail. Now
last income tax return furnished by the addressee.
If in that assessment year he has not
last
filed.
Income tax return you had filed when?
Last income tax return, my lord, filed. Hmm. 27 September 2016, page 88.
And when did you inform about the change of the email ID?
Yes, page, I changed the email ID.
31st October 2023.
No. Yes, 31st October 2023, page 93. Page 93, the screenshot, I am copying fresh, carrying also fresh copy of the screenshot, because this is the half screenshot. Let's just have to do. Page 93. 31st December, I have changed the email ID. The copy.
31st December.
31st October 2023, my lord. May I submit a fresh copy of that page 93, my lord?
Not required, it's there.
Yes. This is the date not mentioned here. The email ID not mentioned here. The new change email ID, it is mentioned here. This is screenshot taken.
Very well.
Screenshot taken, that is from mobile phone. This is from computers. That is the email ID mentioned, the new email ID. And in the portal, page 92, showing the new email ID after change. Thereafter, my lord, page 95, the 148 capital A notice issued, my lord. And reasons for issuance, that cash withdrawal from the bank account, 1.69 crore.
Reasons.
I am not
also yes. But and my lord, the screenshot, kindly have a look of 148 page 115, my lord. 115 is the screenshot, my lord. They sent the old email ID, that sahagroup.in and Basuti 2013 Gmail.
But what about the portal? Why you did not check the portal?
My lord, that para 7 and 8 I mentioned that there was unrest in the tea garden, my lord, and other financial crunches and some problem also in the director and media and already with the worker. For this reason, my lord, it was not possible to complete the audit in time. Thereafter, audit completed.
Mr. Bhattacharya, I am doing this. I will not set aside the order. I will put it in abeyance. He will be entitled to file his reply. He will be heard. And if upon hearing him and considering his reply, the assessing officer reaches the conclusion that there is no requirement of proceeding with, he will drop the proceedings. Otherwise, he will proceed on the basis of the
Only one submission, because I have forget to take this information from the department whether that assessment has been made or not.
No,
Because
no.
Lord, kindly recording submission, no assessment has
Yes,
been
yes. Last, my lord, last notice issued 2009 December.
No, but if in the meantime assessment has been made and I pass this order, then you come with instructions. When can you come back?
Yes.
It will be better. Unnecessarily,
Yes.
tomorrow he comes up and says,
Yes.
now you recall the order.
Even, my lord, in December they issued notice in my one copy in my new email ID and another copy in the old email ID.
Keeping it tomorrow.
Tomorrow will be 2 p.m. because tomorrow morning we have
lot of matters there.
Lot of matters. Then we'll day after tomorrow. Tomorrow difficult.
I have three matters at division.
Tomorrow morning will I have
day after tomorrow.
Yes. Yes.
Tomorrow morning you will not have 5 minutes time, 10 minutes.
Yes, I can have, but I don't know then I can come. Maybe in the list somebody of my juniors will take time. I will come back.
Very well. That is better.
I will also check my portal.
You check it and
because last week I checked, my lord.
Very well.
3 days ago I have checked, but within 3 days I have not checked.
Heard Mr. Rai, learned advocate appearing for the petitioners, and Mr. Bhattacharya, learned advocate appearing for the respondents. In order to enable the learned counsel appearing for the parties to ascertain as to whether assessment order has been passed in the present case or not, list this writ petition once again tomorrow.
And my lord, another
for further consideration. And for further consideration. In order to enable the clarification, and for further consideration, list this writ petition tomorrow.
And lordship knows, my lord, that in spite of the portal, that there are several judgments. I am also kidding.
Yes.
That it is necessary to send registered email ID.
But
I am kidding. Allahabad High Court judgment, our judgment.
That is not his.
Punjab Haryana judgment.
He says in different footings. He says,
No.
I have knowledge from that point of time.
And subject to correction, my lord.
I also said that. I also making my submission.
Continuous fact, my lord. Continuous fact that on 8th March 2024 issued notice. That is not that I am admitting. That is continuous fact of the statement, my lord. I am grateful. Oh,
পাস ওভার একটা ছিল না ওই যার অর্ডার হচ্ছিল Mr. Chakravarti, I am reminding it to the adjudicating proper officer.
Without the issue of...
Yes. We can. This writ petition has been filed. A sale
Number 21.
Well, this Jyotitar is of section 73. And one matter is being heard, my lord, another date my lord has fixed for 74. And here my lord had asked us to file a report. So, and he's enjoying interim order. My lord, let that be disposed of first, then we can, my lord, because that 74 issue is pending, my lord, whether it will be a 74, because his contention was that it should be 73.
This one?
No, that is
73 only. No, there his contention is it could not have been issued at all.
No, he
And
also
74.
he also has taken this point.
74 also.
But
Both
he-
lordships.
He has taken this point that it should be a 73, not 74.
Yes, both.
So that today, my lord, once that issue is decided, then we can go on to this.
When is that coming?
That is lordship returnable tomorrow. No, tomorrow. No, daily tomorrow. Tomorrow. For us to file that compilation of the judgments.
Then we'll reserve it and
Yes,
finish
well,
it.
let it appear in the February monthly list. We'll come back and with the report. This matter.
No, no, why that far?
Oh.
Report. I don't have. I am enjoying stay. Whatever time I learned it.
But after 27th, any 27th.
Liken it, indeed. Mr. Chakravarti, learned advocate appearing for the respondent state authorities, seek some more time to file report.
Twenty-three, my lord, can application, my lord, that can two, my lord, where I have, my lord, prayed to for release of stock, my lord, and I must submit one thing, my lord.
Yes.
I must submit one thing, my lord, that this, after your lordship gave liberty to file, that was withdrawn first, my lord, that's second. Filed on second, and on fifth, my lord, I have my client filed, my lord, memo of appeal against the honorable lordship order, my lord, only to the extent of stay, except the deseal portion of the cash deseal portion, only for stay, my lord, not other purpose. That is, my lord, pending. I must inform your lordship, my lord. But still, my lord, this prayer I have, my lord. Can-
Stay of the adjudication proceedings.
Yes, my lord. Stay of the departmental proceedings, my lord. Because I am challenging, my lord, entire search seizure, the legality and validity, my lord.
Yes,
lordship.
then what will I do here? Till the stay, if it is stayed in any case.
Uh, it is running in the list, my lord,
Then I'm
23.
passing it over. Let us
Uh,
see what happens to that, then we'll come back.
I am leaving to your lordship because
No,
I,
right.
Extend the time to file the affidavit in opposition.
and my lord, yes, yes.
That would be required.
That you will get it there. Before the division.
That I have objection, my lord. I have objection not to, because my lord, your lordship in the 10th order, my lord, 10 December order, your lordship mentioned that matter liberty is given to, my lord, in this order it is mentioned, my lord, that petitioner leave this matter hearing immediately after expiry of the, my lord, this matter, my lord, for the filing of.
Very well, you can pray that before the division bench also. If the division bench doesn't grant, I will grant.
Only to the stand for a stay, my lord. But still your lordship may decide, but I cannot say, my lord. But my duty, my lord.
No, since it is pending at this stage, it will not be proper.
My lord.
Let us see what happens in appeal then.
Only for the stay part, my lord.
Yes, yes, all right.
I am great.
So, next. Not today. Not this week করে রাখুন।
Not this week.
Not this week.
Yes, ma'am.
এটা বের করে দিন, সোমবারে আবার দেবেন, মানে next Monday বা Tuesday হবে।
I am grateful.
I am led by Mr. Arif Chakur. Earlier occasion, the custom authority furnished the report where the admin confirmed that the 8 of bills of entry filed and duty already paid.
Where is Mr. Day?
My lord, I will look on the matter.
Yes.
My lord, we have filed the report on
Who is
in
the effective respondent, Mr. Chakraborty?
my lord, the action has been taken by the
By the
adjudication
state.
order passed by the state.
Yes.
Yes. My lord,
So you are the effective respondent.
Yes, my lord, today, my lord, CGST has given a report. But we do not have access to that report. But I had suggested on the previous occasion that my lord, the demand should be stayed. Just come
That
after.
has been done.
No, my lord, and when the matter may be remanded back to the appellate
Yes, my
authority
lord.
to decide on these issues on the basis of such.
Exactly.
Because the report was not available. That's why it did not accept.
My lord, the bills of entry was not reflected GST portal. Therefore,
No,
demand was there.
that was
They
not-
have confirmed, the petitioner confirmed that it is reflecting in the portal.
So, there was some
Very good.
controversy. Now, my lord can remand back the matter issue and decide the issue on the basis of the report. The petitioner should produce the report.
Yes, he will produce the report before the appellate authority. It will go before the appellate authority again.
Yes.
This writ petition has been filed against an order অরিজিনাল সাইট কল করি 25 ওটা 3:05 করে এটা আপনি উপরে করুন এটা নিচে করে দিতে খুব অসুবিধা হচ্ছে 3 p.m. today now tomorrow
And my learned friend is also not present.
কালকে উপরে দিয়ে দেবেন এটা
Because I was just going to pray for a peremptory order because my learned friend is just playing cat and mouse, my lord.
Mr. Bhattacharya
Okay.
today it's original site now tomorrow it will be at the top now because be here please
I am otherwise ready,
yes
Page 3. ওগুলো তো সব ক্যাশগুলো সেট করা আছে
For the petition. Your Lordship, this is that matter where the entire finding was also a copy paste exercise, Your Lordship. I had already filed my
It has to be placed, my lord. Why this word is really embarrassing me because, my lord, if there is no so-called notice, then where from the he
no,
got?
My
our
learned friend
submission
has
is
not
that,
passed the order.
that even in the findings the same words have been used
Yeah.
that is what her submission
Finding will come naturally from the notice, my lord.
but there should be some deliberation
That
according to us
statement
there
is
is
there, my
none
lord. Well, according to my lord, it has been elaborately discussed, my lord. And my lord, these are all factual aspects, my lord. That question cannot be gone into the read code, my lord. Question is that whether ascertainment of the facts, whether correct or not, that can be only ascertained by the appellate authority or the tribunal, my lord. Read code will see whether there is any factual, whether in violation
Your
of
Lordship,
principle
the
of natural
hearing
justice.
is concluded, Your Lordship.
Had there been any violation of principle of natural justice or perversity, my lord, then read code will interfere with the matter. Simplicity because the facts have not been copied from the so-called notice, that cannot be ground for interfering the high prerogative writs now before Lord's, my lord. The only question of violation of principle of natural justice, my lord. The fact-finding authority, my lord, the adjudicating authority, then will appellate authority, then tribunal, my lord. The read code will not go there. Had it been a case, my lord, hearing has not been given, or any perversity, or law has not been, my lord, followed by the adjudicating authority, that question can be gone into the read code, my lord. Otherwise, read code cannot go into the niceties of the facts, my lord. Facts cannot be decided in the read, my lord. These are all disputed questions. Then, in a suit, it can be, my lord. In a read, it can't be, my lord.
very
And my lord, a clear case, I have stated, my clear case of my abatement there. Even then, my lord, irrespective of that, is clear case of abatement, my lord. He himself of his own pocket, my lord, clearing the goods. And email, my lord, we have referred there, my lord. By the email, he knows the goods containing the poppy seeds. He knows everything.
Your Lordship,
Knowing
I
fully
have,
well, he, my lord, released the goods from his own pocket, my lord. I have stated in my written notes of argument.
Your Lordship,
That
I have not
question kindly,
received a
my lord,
copy
consider.
of his written notes of argument. I have
exchange
and
exchange
Your Lordship,
exchange you give yours
Your Lordship. Your Lordship, I have restricted to principle of natural justice. I am not arguing the matter again, Your Lordship.
And my lord,
Your Lordship, I had demonstrated clearly, Your Lordship,
I'll consider
Your Lordship.
it's there in your written note
Your Lordship, and Your Lordship, I handed over one page from the show cause.
you have
Your Lordship. Yes, marked.
yellow
Your Lordship.
highlighted in
Your Lordship.
I've read it
Your Lordship. Your Lordship. And
Uh,
Your Lordship, the two circulars also I had handed over. What is that clearing agent should not be implemented in a routine manner. And those circulars also, Your Lordship, it is there in my notes, and I had handed over at the time of argument also the judgments and
very
the circular.
heard learned advocates appearing
lord, Ponzi matter is going on, my lord. My lord, last time around, Mr. Kundali had handed over certain instructions, my lord. I'll just two letters were written, my lord. We had written to the customs broker saying that we do not have any objection to handing over, releasing the F license, whatever. And after that, my lord, on 31st December, we have again written to the customs. Calcutta has written to customs Mumbai that controls this CBLMS, that is the portal that handles this customs broker portal thing. That we do not have any objection on principle. You can take steps to cancellation of the F pass so that he can do his own business later on. So this has been done on 31st December, my lord. So it's my lord 13. Today is 13. So my lord, maybe they would have taken a taken a decision or not. My lord, I do at this point. I think we have done enough. My lord, all that we can.
Your Lordship, Your Lordship on the last occasion had directed that we should serve the
Yes,
employer.
that's
Your
point
Lordship,
number
we have, yes, Your Lordship, we have served, but they are still not here. Secondly, Your Lordship, the department had itself issued a reminder saying that if they don't reply within 7 days, they would delete my name. That reminder letter, Your Lordship, just after filing of the writ, Your Lordship, I was served with this reminder letter. But Your Lordship, they have not deleted it within after 7 days also. Your Lordship, I am praying for this direction so that I can get employed somewhere else. Your Lordship kindly directs them to delete my name within a time frame so that.
direct you to delete.
My lord.
Because you also have no objection. You have given a
No,
reminder.
my lord. No, my lord.
लिखे नहीं. This writ petition has been filed seeking issuance of a
proceedings.
Wait, Kulya. Next.
Item number 3.
Please, Madam, I'm appearing online in item number 3. My colleague, Mr. Dey, is there, my lords.
Yes.
My lords, in this case, we have challenged the 148 proceedings. And
Yes.
what had happened is that this is a case of an individual. And if my lords will see annexure A4, sorry, P4 at page 98 of my writ petition, this is the 148 capital A1 notice. Sorry, my lords.
Well, only one submission for my learned friend start. Now, that perhaps he had good case, but I am questioning the filing of the writ petition by affirming by notary service. Now, this is a circular of the High Court Calcutta. It says, initially, power was given. Thereafter, the Honorable Chief Justice withdrawn the power. By notary, the.
But he is staying out of Calcutta, my lord.
It cannot be said the rule can be changed.
Yes, Mr. Dey.
Well, at that time, I mentioned one matter before the erstwhile Chief Justice for giving permission to allow me to file the appeal by notary. And court has
Leave may be granted.
For outstation also, it is not permitted.
Yes, outstation my stays at Delhi, my lord.
Should be permitted. Should be permitted. Outstation also it should be. Notary public है तो है तो petition. Yes, I think it should be. Anyways, what is there on merits?
Yes, my lord. My lords, as I was saying, if my lord will see annexure P4 at page 98, this is the 148 capital A bracket 1 notice that the department has issued to me. And para 2, my lords, they are saying I am a non-filer.
Page 98.
Page 98 is the 148 A1 notice.
Yes.
And para 2, they are saying I am a non-filer. The second line, my lords. In this case, for AY so-and-so under the category of non-filer. My case was picked up for reassessment as a non-filer. Now, if my lords will see at page 100 onwards, which is annexure P5, I filed my reply stroke objections to the learned officer. Page 100, my lords. Just, and if my lords will see, from page 101, para 1 onwards, I have shown everything that this is my salary and everything. I am a salaried employee of Reckitt Ben-Kaiser, my lords. And if my lords will see page 103, I have shown a return of 3 crores 73 lakhs, which is the salary return. And then, my lords, kindly see, I've also annexed all the summaries, the taxpayer information summaries, information summary, my form 26AS and all those things, along with this reply. Now, kindly see page 8, 113, which is the order of the learned officer under section 148 capital A bracket 3. Page 113, my lords. He takes on record my reply.
But Mr. Dey,
Yes,
if he is resident at New Delhi,
yes.
on 18 September 2025, he did not come to Calcutta.
He could not come, my lord.
Notary is from Delhi.
Yes, my lord. Yes, yes. I have not done anything from here. He has done there and send it to me, then I file it, my lord.
Page 122, my lords, para 5.
Page
122, my lords, para 5. He only says that because in Anshul Jain, which is the Punjab High Court judgment, the marriage system,
your objection has not been dealt with.
nothing dealt with, and he has got no objection also, because they picked up my case as a non-filer. I am not a non-filer. I have shown 3.75 crores as income from salary.
That is because I have placed this circular.
And also one more thing, my
It
lord,
has to go.
I have one
Let him redecide this. Let him
my,
redecide.
my colleague has
Yes,
the
I have heard it. I
yes,
heard
my
it.
lord. Yes, my lord.
Redecide. Let's go back.
Yes, sir.
But my lords, I bow down to what my lords are observing. But this can be disposed of here only because there is no case at all. It's only a
No,
case.
no. Let them decide once. Why? Unnecessarily, why should I? I will have to
Okay.
decide the factual things also. Let them decide it.
Okay, my
Their
lords.
objection
I
has
bow
not been
down. I
dealt
bow
with.
down to that.
But what about this notary aspect, Mr. De?
Yes, my lord, that is what I have submitted, my lord. Because he is staying there, my lord. He could not come. That is why it has got it notarized in there. They are from there. Then I have filed it. Not from here. Anything.
Regional side rules say.
So also I cannot support this notary.
We'll have to look into it.
You have to support. You can support.
Kaushik Roy, the petitioner, in the cost title, it says Adunika Lake Garden, Kolkata 45.
His address. Others are there, but he was not there during that time.
Others are কোথা থেকে? এটা তো কৌশিক রয়েরই মামলা।
আরে বাবা, ফ্যামিলি এখানে থাকতো। ফ্যামিলি আছে একটা তো।
ফ্যামিলি?
তাও থাকতে দেবে না? বাবা মা আছে তো একটা কারণ। ঠিক আছে। যা বলবে ভাই। কিছু করার নেই।
Yes, Mr. De. On this, we'll have to come back. I will also have to check.
Yes, my lord.
But I also will check that I have not given so much
Chapter
time.
15, Rule 5.
Chapter 15.
देखिए heard Mr.
Vishal Kalla.
Mr. Kalra, learned advocate, appearing for the petitioner, and Mr. Bhattacharya, learned advocate, appearing for the respondent income tax authorities. List this matter for further consideration tomorrow. Tomorrow,
yes. Because I have no submission in merit before.
Let the affidavit service kept on record, subject to lordship pleasure.
affidavit of service filed in court today is taken on record.
Or your lordship hard
Grateful, my lord.
I've
We have
written,
asked,
I've written heard.
heard the parties.
deeply obliged.
Deeply.
Grateful, my lords.
So, matter.